Good morning, everybody. In accordance with Sections 45 and 53 of the Planning Act, 1990 as amended, this meeting of the Committee Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. We acknowledge the land we are meeting on as a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. To those who want to participate virtually and have registered in advance, will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5 minutes allotted speaking time. At all other times, your video will be disabled and you'll be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with a written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during video appearance. The host will remove you from panelist if you fail to respect that instruction. People attending in person today or who want to receive a copy of the decision of the Committee of Adjustment must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. I will call each item in the order listed on the agenda. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5-minute time limit. Any presentation or other material you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then, individuals, either in support or opposed to the application, will be invited to speak. Generally, we call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant or agent has the opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for decision. Now, before we hear the first item, we need to confirm the minutes of the last meeting.
Through you, Mr. Chair, we have one set of minutes to approve. Olivia is going to read out the names of the members that were present for November 9th minutes.
Member Allison, Member Mazzari, and Member Auspis were present.
So we just need a motion to approve those minutes, please.
Can I have a member to move that motion?
I'll bring the motion to approve with no condition.
These are minutes of November 9th.
Okay. We have a seconder. Second by Mr. Auspis. All in favor? Okay, the motion carries.
Oops. Mr. Chair,
Yes,
before we carry forward, can I ask for an additional motion this morning?
of course, yes.
It's a motion to not excuse any absences, that the North York District Panel of the Committee of Adjustment does not excuse any member absences from the December 7th, 2023 North York Committee of Adjustment meeting.
Okay. Can I have a member to move the motion?
I'll move the motion.
Ms. Caston moves the motion. Can I have a seconder? Okay.
Mr. Chair, can I have a seconder, please?
Yes, second by Mr. Marziari.
Thank you.
The motion passes. Do we have any deferral requests?
Mr. Chair, do you want to go through any conflicts this morning first?
Of course. Do we have any conflicts of interest of panel or staff at this time?
Mr. Chair, I have a conflict on the afternoon agenda.
Okay.
Okay, well, we'll cover that in the afternoon.
Any other conflicts this morning?
So item 11, I'm declaring conflict because of
Okay.
knowledge of one of the applicants.
Just for the record, Mr. Schwartz has and what is the reason for the conflict?
Knowledge of one of the applicants.
Sorry, could you just state that again?
I know one of the parties.
Sorry, Mr. Chair, I didn't hear the item number.
Number 11.
Number 11.
Number 11, Mr. Schwartz. And he stated that he knows
One of the parties.
one of the parties.
So just to confirm, that is 6 Carmichael?
Yes.
Correct.
Thank you. So when we come up to item 6, if the member can leave the chambers.
11? 11.
Sorry, 11. Item 11. Thank you.
Okay. Have you received any requests for deferral?
In the morning, we have 1, item number 4, number 1, Braeside.
Okay, thank you. And do we have any files to be closed?
Through you, Mr. Chair, there are no files to close at this time.
Okay, thank you. Okay, it looks like we're ready to move to the first item of the day.
What, Mr. Chair, through you, can we do the deferral first?
Yes, let's deal with the deferral first. Okay, so just give me a moment here. Okay, so item number 4, address is 1 Braeside Crescent. The purpose of the application is to construct a new dwelling with variances for lot coverage, building height, side exterior main walls, and platform area. Submitted, I have material from the applicant, including drawings, arborist report, as well as 2 memorandums from Urban Forestry, as well as letter of objection from number 3, 108, 114, 116, and 118 Braeside Crescent. We have the applicant online.
Good morning, Mr. Chair. My name is Andy Xiao Huang, and I am the agent for the application. My address is 49 Glengarry Circuit. And we would like to request a deferral for our application due to the receipt of number of a letter of objection and some comments from the Urban Forestry. We would like to address those issues and comments raised by the neighbor, and we will come back to the hearing afterward.
Okay, thank you.
Thank you.
Do we have any questions of the speaker? Nope. Okay, I believe we have 2 other speakers on this item. Do we have them online with us?
This is Anand Jaggi here from 116 Braeside Road.
Good morning. Do you have any comment with respect to specifically with respect to the request for deferral?
None
Okay.
at this point.
Okay, thank you. We have one more speaker.
Stephen at 114 Braeside. And I'm happy that the application has been deferred due to the opposition. The neighbors haven't been, kind of even consulted about this. The old oak tree in the back, the applicant had poisoned it over the summer. And we still haven't heard from the city. They have thought they saved the tree, and the forestry department hasn't returned our requests for information on how that's going forward. One of the trees, a 60-foot Douglas fir, doesn't even appear to be in way of the construction, yet is deemed for destruction as well. So hopefully we can get some more information on these items. Thank you.
Okay, thank you. We have no others, just to confirm, we have no other speakers on this item? None? Okay, thank you, staff. Do we have a motion? Or I guess before I ask if we have a motion, do we have any questions? No? Okay, let's move this into committee.
Could I put forward a motion to defer?
Okay,
Sorry. I would like to put forward a motion to defer the application to address comments of neighbors and forestry.
Thank you.
I'll second that. Larry?
second by Mr. Schwartz. All in favor? Okay. The item is deferred.
Through you, Mr. Chair, we have a very last minute request for deferral this morning.
Okay. Which item number?
It is item number 8, 521 Davisville Avenue.
Okay.
If we can have the agent online, please.
Yeah, just to summarize, the address 521 Davisville Avenue, proposal to construct a new 3-story single-family detached dwelling and a garden suite in the rear yard, with a number of variances tied to this application. Do we have the agent or applicant with us?
Yes, I'm here.
Could you please state your name and address for the record?
Anthony Abate, 63 Pioneer Lane, Woodbridge, Ontario.
Okay, thank you. And you were requesting a deferral?
Yes, as of yesterday night, we received a letter from Urban Forestry requesting to deny variance number 6 on the application. And there's a fear that the construction of the foundations would require removal of a 60 centimeter sugar maple tree that's shared along the property line between the two houses. Based on that, we'd like to have more time to work with Urban Forestry and do an exploratory excavation to, and with the idea to ascertain an arborist report, which will show that we can protect the tree through the course of construction. So we asked the committee that we can defer this hearing till the next available date so that we can ascertain an arborist report to their satisfaction.
Okay, thank you. Any questions? Okay, we have another speaker in person. Sir, would you come down to the podium and state your name and address for us? And I'm going to ask you specifically if you can speak specifically to the deferral request.
Okay.
For us.
So my name is Tom Quinn. My wife Marianne and I live at 517 Davisville Avenue, which is the house to the immediate west of the applicant, 521 Davisville. It's the neighbor on the other side that are dealing with the trees. I know you asked me just to speak to that. We'd be okay with the deferral, but I'd like the condition that there be consultation with the neighbors, both the neighbors, in advance of coming back to committee.
Okay, thank you very much. Do we have another speaker on the line?
My name is Arlin Morgan. I am the neighbor to the other side at 523 Davisville Avenue. I live here with my husband and our young daughter. I just want to start off by saying that the two trees that are, or the one tree that was actually spoken about is actually not shared. It is on my property. And there are two trees that Urban Forestry will be looking at during their observations. We do agree that, yes, this does definitely need to be looked into. And we do share the concern of the other neighbor that prior to coming back to committee, we would ask that the owners actually have to dialogue with the neighbors prior to deadlines of committee of adjustment.
Okay.
As this year it was done after deadlines.
Okay. Okay, thank you. Do we have any questions? Mr. Auspitz?
I'd like to just make a statement. Asking for neighbor consultation before coming back to committee is outside of the Planning Act process. So we can't, I think it's very difficult to impose that. I'm seeing it come up a lot.
Through you, Mr. Chair, you can pose the question or the request to the applicant directly and get a response.
Yeah, so I would like to speak with the applicant. I do have a question of the applicant, but I would like to hear from other parties first before I ask that question. I believe we have one more speaker.
Hello, can you hear me?
Yes, we can hear you.
Yes, my name is Al Keavy. I'm a representative of the South Eglinton Davisville Residents Association. I'm a retired engineer by profession. I've identified a large number of deficiencies in the plan, and I'm working with the zoning examiner to have those deficiencies in the plan rectified. So any new plans, I mean, it's not within the purview of this committee, but I just want for the record to notice, to advise the committee that the plans are deficient.
Okay, thank you. Any questions? And I apologize. I believe we have one. Do we have one more speaker here? I see a note that this person may not be speaking. Staff can confirm.
No, the last speaker will not be speaking.
Okay,
Are you referring to David Bostock?
I am.
That's correct.
Okay,
He will not be speaking.
thank you, Mr. Secretary Treasurer. Okay, if we can get the applicant back.
Yep.
I have a question, and I'll give you a chance to respond. But it seems like the neighbors are requesting some consultation in advance of coming back to committee. Perhaps you can speak to that. And anything else you'd like to add?
I have no objection to informing the neighbors. We all met together Monday night, this past Monday, and had a pleasant evening as I walked them through the plans, and I would enjoy doing that again with them.
Okay. Any questions? Okay, no questions. Okay, let's move into committee. Mr. Schwartz.
I'll make a motion to defer.
Okay, and the reason?
Reason is there's no objection to deferral. The applicant has agreed that he's going to consult with the residents.
Okay, thank you.
Sorry, Mr. Chair, I think there was also a forestry concern the applicant was going to work on.
Okay, the deferral is subject to the applicant working with forestry to resolve any outstanding matters with forestry.
Okay, thank you. Do I have a seconder? Okay, second by Ms. Casson.
Yeah, go ahead.
She beat you to it. All in favor? Okay, the item is deferred. Thank you.
Thank you.
Okay. That takes care of our deferral requests this morning. I am going to, if you have, just send that over to staff. Okay, so jumping back to item number 1. Property address is 141 Riverview Drive. The application is for consent and for minor variance, specifically lot width and side yard setback. On file, I have applicant's materials, including a planning rationale report and drawings, as well as a memorandum from Urban Forestry, memorandum from Engineering and Construction Services, emails from Marine and Natural Feature Protection and Community Planning, a letter from the Toronto and Region Conservation Authority, as well as a late presentation from the agent. Do we have the agent with us online?
Yes, good morning.
Good morning.
My name is Andrew Franic. I'm here.
How are you?
Very good, thank you. How are you?
I'm well. Can you please state your address for us?
Certainly. So I'm Andrew Franic. I'm the principal of W&D Associates. We're the planning firm that's retained on this matter. And our address is 90 Eglinton Avenue East, Toronto, Suite 970.
Okay, thank you. I believe you prepared a brief presentation for us this morning?
Yes, Mr. Chair. I would like to have about 3 minutes to run through it quickly and just run through the highlights of this proposal.
Okay.
If I could ask that the next page be turned, please. This is just a context image that shows the location of the site on the north side of Riverview Drive. The address is 141 Riverview Drive, and it's in the Teddington Park neighborhood just east of Yonge Street, and it backs on to the Rosedale Ravine and the Golf Club. Next page shows some of the on-site imagery of the tennis court, and the tennis court is essentially the location of the proposed consent. And the consent is to add a small portion of the adjacent lot because there is an underlying plan of subdivision that pertains to this entire property, and to add it onto and enlarge essentially the area of the tennis court so that it can be later sold for a larger building lot. And so here are some photos of the tennis court, and then the adjacent pool house, which would be on the retained piece of land adjacent to the new lot. And the next page just summarizes the elements of the consent application. And as I mentioned, there is an underlying plan of subdivision. The lot that this pertains to is lot 85, which is the westernmost portion. And then there's a small portion of lot 84 that is 2.76 meters wide that's proposed to be added onto lot 85 to make it 17.99 meters in width and 1645 meters in size. And that's illustrated on the next page. And Mr. Chair and members of the committee, the reason for this is to essentially just make a slightly larger building lot. My client could convey, it could sell the land now, given that it's part one is already severed or part of a plan of subdivision, I should say. And this is simply a proposal to enlarge the lot and to retain the balance of the lot for the residential dwelling that's on the property. If we can move on to the next page. And just in terms of rationale, the proposal being to enlarge actually will bring the lot more closer into conformance with the general lot pattern in the area. And so you can see on the left-hand side, there are some metrics given here for other lot sizes, lot frontages, 12.5, 15.5, 15.7, 18, and then some larger lots. So there's a mix of lot sizes in this area. The lots generally trend larger on Riverview Drive, and certainly this will maintain that character, and in fact enlarge an existing lot. The next page over, please. So the proposal also comes with two variances, and the variances are actually firstly for lot frontage. So despite the lots actually being enlarged, it's currently undersized. It will have a lot frontage of 17.99, whereas the underlying zoning requires 22.5 meters. And so there's a variance required for that, notwithstanding that the lot's getting bigger. And then the side yard setback of 1.5 meters is requested to conform to the standards for lots that are less than 18 meters. That's opposed to the 1.8. So there were no objections that we saw with respect to any of these variances or the consent on file from either city staff or through public consultation. And the TRC as well is in support of this. Next page over is simply just a demonstration plan of an as-of-right form of dwelling that could occur on the lot. That's something that isn't directly proposed, but it just shows simply that a typical house that's characteristics of this neighborhood could actually be built on this lot. And the last slide that I've got for you, just a little bit of summary of our rationale for this. In my opinion, the consent meets the requirements under Section 53 of the Planning Act, creates for an appropriately sized lot that's suitable for future residential development, perhaps along the lines of what I just showed you, meets the 4 tests under the Planning Act for the 2 variances with respect to providing for appropriate standards for this lot, and it provides for alignment with the overall character of the area, and it also has satisfied staff and TRC. And I don't believe there's any public opposition to it either. So with that, I would say thank you for listening, and I'm here to answer any questions that you might have.
Okay, thank you. Do you have any questions? I just have on my notes here, believe there were some recommended conditions from community planning and urban forestry. Are you aware of those?
Yes.
Okay. Do you have any issue with those recommendations?
No issues with the recommendations.
Okay, thank you. If there's no other questions, we'll move this into committee.
Sorry, Mr. Chair, before you commence, did you reference a city planning staff report? Sorry, I missed what you said.
I did. Can we pull it out? I just want to confirm.
I don't see any.
There's a memo. Let's pull those up. You see those there?
That's the engineering one. Okay.
Engineering and construction services.
Okay.
Through you, Mr. Chair, there's a memo dated November 23rd from staff, Denise McMullen, with a list of conditions.
Thank you.
And they're up on the screen there.
Okay, thank you. Any other questions? Okay. Let's move this into committee.
I don't have any real concerns. It appears that a plan of subdivision is not necessary for this boundary adjustment. The minor variances are relatively minor. The relief sought is relatively minor.
Okay. We have a motion.
I'd like to motion to approve the consent application as well as the minor variance application, subject to conditions of planning, transportation, and forestry, as the application complies with Section 5124 and 53(1) of the Planning Act, as well as Section 45 of the Planning Act.
Do we have a second?
I second that.
Okay, second by Mr. Marziari. All in favor? Okay. Application is approved.
Thank you.
Okay, item number 2. 15 Charlemagne Drive. Just give me a moment. Purpose of this application is to obtain consent to sever the property into 2 residential lots. Do we have the agent on the line?
Yes, good morning.
Good.
My name is Frank Michelli, appearing as agent.
Okay. And your
my
address?
is 40.
Yep.
My address is 40 Avenue West, Unit 2, Vaughan, Ontario.
Okay, thank you. For submission, I have a letter and supporting material from the agent, as well as a memorandum from Engineering and Construction Services, as well as Transportation Services. Have you, you're aware of the recommendations from Engineering and Construction Services, as well as Transportation Services, I presume? I should also add in community planning. I know they had some recommendations that came in late.
I've had a chance to review these ones here. Yes.
Okay, and no concerns with those recommendations?
No, the only thing that I would say is that the one number 2 regarding municipal numbers, you can see from the photos that the lots have already municipal addresses. But this shouldn't be an issue.
Okay. Members, does anyone need to hear a presentation on this? Would anyone like to hear a presentation on this? Okay. I'll go back to the applicant. I mean, the floor is yours if you'd like to say anything, but I believe we have all the information we need before us.
No, it seems pretty straightforward to me. So unless you have any questions, I'm fine.
Okay, thank you. Okay, move into committee now. Mr. Auspitz?
I don't have any real concerns. It appears that there are 2 dwellings on the site. The proposed lot would separate those back in those 2 original dwellings. They probably were at some point under separate ownership, and the consent appears to be appropriate.
Okay. So do I have a motion?
Sure. I'd like to motion to approve, subject to conditions of transportation, construction engineering, as well as planning. And I just want to make sure, and yes, that's it.
Pull your mic down. We can hear you. Pull your mic down a little bit. There you go. Okay. Do I have a second? Second by Ms. Casson. All in favor? Okay. The application is approved.
Thank you.
Thank you. Okay, moving on to item number 3, 183 Hannah Road. The purpose of the application is to construct a new single-family dwelling with variances requested for soft yard landscaping, building height, main wall height, building length, building depth, FSI, north side yard setback, south side yard setback, as well as driveway width. Material from this on this file I have from the applicant, including drawings, a cover letter, diagrams, and an arborist report, as well as a staff report from community planning. I have a memorandum from transportation. I have correspondence from Metrolinx. I have a letter of support from 136, 169, 177, 178, 179, 180, and 182 Hannah Road, as well as 75 and 79 Vanderhoof Avenue. I have a letter of objection from 184, 189 Hannah Road, as well as 96 Parkhurst Boulevard, number 6, 25, 31 Parkley Drive, number 230, 232, 234, 236 Rumsey Road, 173, 174, 175, 182, 183, and 187 Hannah Road, as well as 83 McRae Drive, and the Leaside Residents Association. I've got planning report from the agents representing 185 Hannah Road, as well as a late email from 185 Hannah Road. Excuse me. Do we have the agent with us? Good morning. There's a button.
Hi.
There you go.
My name is Brenda Eisen. I'm the agent for the applicant at 91 Tychos Drive in Toronto.
Thank you. You have a presentation for us this morning.
I do, yes, and I see my supporting material is already pulled up. Thank you for that. So I'm here today with a proposal for a new 3-story house on Hannah Road. We were originally scheduled to appear at the July 27th hearing with a proposal that was pretty significantly larger and a more modern architectural aesthetic. It was not easy. And it is not easy to work within a territory of such an established change-adverse neighborhood association. But after receiving their feedback and from planning staff in the 11th hour, we decided not to move forward with the hearing in order to take the opportunity to incorporate all of the feedback that we received. We made significant reductions and revisions, which are detailed in a cover letter that we submitted with our new drawing set. Most of the comments we received initially were centered around the physical characteristics of the Leaside neighborhood and the desire to maintain uniformity. The Leaside residents were very clear that they want conformity. So we dove into an intense study of the greater context and the specific context, and we identified certain architectural elements that define the neighborhood, which you can see in this slide. The homes are predominantly brick. They predominantly appear to be 2 stories on the street wall side. The street wall height is more or less consistent from one house to the next, and they have pitch roofs that slope back toward the peak of mixed roof types, including gable, hip, and mansard roofs. The front setback is consistent from house to house, and the homes all appear to be extruded boxes without depth or variation in the front elevations. Next slide, please. We incorporated all of these elements into the redesign of this house for something that really fits seamlessly within the neighborhood context and the neighborhood plan. The neighborhood plan states that the character of the neighborhood will change over time in small increments, and this home that we're proposing today embodies that incremental step forward in time without compromising any of the defining elements of the neighborhood. Today we're seeking 9 variances to the bylaws, 2 of which are for landscape. Even though the majority of this house does comply with the zoning bylaws, as noted by planning staff in their report. Upon first glance, a couple of these might seem like deviations from the prevailing character of the neighborhood, but they are each quite minor in nature, and I'd like to explain a couple of them with the graphics that we've prepared. The first one is for variance number 3 for the main wall height. So the main wall height at the street does not require a variance, and it falls within the average level of all the other neighborhood homes. From there, it slopes up towards the 3rd story, which is entirely hidden from the street. It reaches its full height of 8.85 meters, almost 7 meters back from the front wall. And this height condition is only present for 6.5 meters of the total perimeter of the house. So that's the area shown in red there on the bottom, on both diagrams actually. The other side of the 3rd floor is set back 3.5 meters from the side wall. So this height has virtually no impact on the side neighbors. And actually, if this house fell into the new zoning bylaws with a flat roof and the regulations for the stepping back of the building mass, we wouldn't even need a side wall height variance, as you can see on the next slide, because we meet the 1.4 meter setback and the stepping that's required, and the reduction of building footprints above the street wall height. Next slide. With respect to the building length and depth, variances number 4 and 5, the majority of the house is actually under the maximum 17 meter length. The entire ground floor stops at 16.23 meters, and the 3rd floor also does not exceed this length. Only a portion of the 2nd floor comes out to our variance ask of 20.79 meters. And this was located on the south side intentionally to line up with the wall of the existing neighboring house, which right now is just a big brick wall that abuts the existing backyard of 183. It does not affect anyone's views or light because of this alignment. And then finally, for variance number 7 on the next slide, which is the side setback, there's a very small portion of the ground floor only that bumps out to the north. The house isn't exactly parallel to the lot line, so the 0.61 meters that we're asking for is measured at the very tightest spot of the top left of that blue rectangle. There are no windows on this bump out, and actually there are very few windows on the side elevation altogether. So the majority of the ground floor, as well as the entire 2nd floor, are set back on the north between 0.91 meters and 1.47 meters from the front to the back of the house, with the exception of this little blue rectangle. I believe the other variances are self-explanatory, but I'm happy to answer any questions from the committee or the neighbors. Ultimately, I ask you to defer to the expertise of city planning and their recommendation that this home is contextual within the neighborhood and reinforces the stability of the neighborhood.
Okay, thank you very much, Ms. Eisen. I have a question for you with respect to actually what's up on the screen, the diagram that you provided, showing the side yard setback. So are you suggesting that outside of that blue zone, you would not essentially require a setback there?
The setback requirement is for 1.2 meters, so we would require setback because at the front corner, we're at 0.91.
Okay.
And then it ranges all the way to the back of 1.47, sorry. So we would require a variance either way, but the setback that's asked for in the public notice and in our zoning review actually just appears to be a lot smaller than what we're proposing.
Okay, so if I understand correctly, at the front of the dwelling, there is a 0.9 meter setback. You may require setback for other parts, but the blue portion indicates the most extreme, I guess, condition we could call it. The 0.6. So we point. Sorry, 0.6 meter. 0.6 meters.
0.61, yeah, that's exactly right. So the blue portion is the most extreme, and because the lot line's not parallel, it's only 0.61 on that very tightest corner. So it's a range of setbacks, but the blue is what's triggering the most restrictive variance.
Okay. Any other questions?
I have a few questions on the side yard setbacks. This is one of the largest, widest lots. Have you? So it. I mean, you would, and a lot of the dwellings don't take up their whole. Have you considered how having a wide dwelling, like a dwelling that would appear to be much wider, would relate to the prevailing mass and scale?
We have considered it, yes. Thank you for your question. The home that's on the existing home at 183 Hannah actually has smaller setbacks than what we're proposing. So the net effect of the overall mass and scale is actually that there will be more space between the home on the north side. The south side is actually identical, so it is currently 0.91, and we're applying for 0.9. There's actually a shared walkway between the home to the south at 179 Hannah, I believe, and 183 that we submitted a photo of with actually the incorrect address, and the neighbor corrected it. But it's also the home next door to the south at 179 is not parallel to the lot line. So you can see the corner of it in the slide that's up right now. So even though we're not considering what's happening on adjacent properties, our 0.9 meter setback, which is 3 feet and totally adequate for independent access to the backyard, even if there were a fence, that 0.9 plus their 0.9 only happens in one spot, and it's all a shared walkway, and it's intended to I guess not preserve, but to replace this walkway with something equally functional for both neighbors.
So, so I'm looking at the survey that was provided. I don't see any, I recognize that there's a walkway, but do you have rights over that neighbor's walkway?
No, not at all. Sorry, I meant to answer your question about the overall effect on the massing in the neighborhood. And what I intended to communicate is that the current south setback is 0.9 meters and the proposed setback is 0.9 meters. So regardless of what happens with that walkway, the massing will remain the same and the effect will remain the same on the south. And on the north side, we are actually increasing the setback, so the massing will appear to be smaller and it'll be more functional. Although it's really not that functional right now. They just keep the garbage bins there.
So my understanding with respect to the walkway, there's no access that's being hindered from these variances, that they're maintaining that 0.9 meter setback.
Correct. From the perspective of the south neighbor, aside from the construction, once that's complete, nothing will change in terms of the access in the walkway.
Okay. We have another question?
Yeah, I have a question from the applicant. In regard with variances number 4 and 5, building depth and building length, you mentioned you are aligned with the south neighbor. Can you go back to that slide? Okay. Do you have the south? Oh, okay. So the length of the south neighbor noted here, 1788. Are you also aligned at the front and at the back, or just at the back, and the south neighbor is further, has more front yard setback? Just want to clarify that.
Yeah, thank you for your question. We're not completely aligned at the front. We're situating this house at the minimum required front yard setback. We're just taking advantage of the condition at the back, I guess, where you see that the brick wall from the existing backyard to butt the space up against there. So it's what you see here, the dark gray volume of the south neighbor is their building proper, but they actually have some dormer windows at the rear that come out further, and that's kind of where we're taking our guide from. And then that light gray volume is they have an attached pergola or cabana, I guess, that's covered and it's open, it's not enclosed, but it's an extension of the building structure, and so it comes out pretty far into the yard. And as I mentioned, the siting of our second floor extension there, which is not on the third floor or ground floor, doesn't affect, it's to the north of them anyway, but it doesn't affect anyone's lighter views because of how their house is designed.
And these two variances are not related to the north wall, correct? It's just about the south side of the building.
Correct. It's just the south, and it's just the second floor in that location.
Okay, thank you.
Thank you.
If I'm reading the drawings correctly, that section is just, it's cantilevered over. It's a bit of a unique condition. Typically we're used to seeing that larger, footprint on the ground level, but in this case they've maintained the ground level and extended above. I am curious, and the reason I ask now is because I don't see a speaker for that address to the immediate south. I am curious to see a photo of what that extension looks like. That would permit that additional building depth on the neighboring property, but perhaps we'll get to that in a bit.
I don't have it as part of my material, but I can send it in to staff before the end of the opposition speaking, so you can see it during this file. Before
Maybe, if it's okay, maybe we'll just pull that photo up on the screen.
I just don't think they have it yet.
If we have it available. Okay. Thank you, Ms. Ivan.
Thank you.
Do we have another person here today to speak from, I believe, 171 Hannah Road?
Well, maybe I should ask them. May I ask a question?
Oh, of course. Sorry. We've got another question for you.
Sorry, so just, my questions are maybe just general. You said that you brought a previous application. You brought a previous application. Are you able to hear me? You brought a previous application, then withdrew it so that you could bring this one. And you met with the residents?
The homeowners who are building the house at 183, they reached out to all of the residents on more than one occasion. To my knowledge, there were no meetings.
No meetings. Why were there no meetings?
That is a very good question. I don't think the proposal was met very favorably.
When I read through the objections of the residents, amongst them, some of them have highlighted the design. We're not here to deal with design, rather Planning Act issues. However, I just wondered, in light of the residents' concerns with design and so forth, why there wasn't. I mean, you said it was a good question. I just don't understand it. There's nothing more you could say to explain why there were no meetings.
My impression, and I could be mistaken, is that the residents of this particular neighborhood sort of speak among themselves in a more, in a less open fashion. And even though that my clients had reached out to them, had gone around the neighborhood specifically, I know for sure with the two immediate neighbors on more than one occasion, and back since 2 years ago when they purchased the property, not just 6 months ago when we were supposed to come to committee for the first time. The first time that we received proper feedback were the letters of opposition that came in for the July 27th hearing that also related very much to the design, and that's what we've taken to heart and applied and come back with. But I don't believe, oh sorry, there was a meeting with a resident to the north recently, but they still submitted 2 letters of opposition from that address.
Okay.
Perhaps we'll hear from the
Yes.
from the
Sorry,
other
I wasn't
parties.
part of any of those meetings, so I can't really speak to them.
Fair enough. Okay, thank you. Do we have Mr. Jordan here from 171 Hannah Road to speak? No? Okay. Staff, I understand there are a number of speakers. Perhaps we can pull the first speaker up to hear from. Is there anybody? Actually, I should ask: is there anybody here in the gallery to speak? And would you be able to come down to the podium for us and state your name and address?
Catherine Bowman and David Sprague at 185 Hannah Road. But we requested to speak last of the objectors.
Okay.
And
Okay.
we do counter some of the statements that were made that we believe are untrue.
Fair enough. We'll get to that. Okay. Then let's jump to our online speakers. We can have the first speaker with us.
Morning, I believe you are waiting for me. This is Michael Barton of MB1 Development Consulting.
Good morning, Mr. Barton. Would you be able to state your address for us for the record?
Yes, my address 1489 Abbeywood Drive in Oakville. I have prepared a submission on behalf of the owners of 185 Hannah Road.
Thank you. Yes, and we have received that submission as part of our package. Would you like to present for us?
Yes, I'll just go through and highlight the elements of what I submitted that I think are relevant to the committee's consideration today. So, as I noted in my document, it's key to note that the existing house on this property is a 2-story single detached dwelling. As noted, it has a pitched roof sloping down in height from front to back. It helps provide variability in that maximum height, particularly the greatest height towards south and lower height towards the north property line. That helps to mitigate the overall massing of the property relative to those properties and the street. And it's important to note, I guess, as well, we've heard that the property does have setbacks that are 0.71 meters on the north side and 0.9 on the south side lot line. So again, the neighboring properties, 179 Hannah, which we'd heard about, it did receive minor variance approval in October of 2008. So it was approved to have a 0.45 meter side yard setback on both the north and south side. And it was approved with a dwelling length of 17.92. So the original proposal on that property was for 18.3, but it was reduced to 17.92 after a deferral. So in looking at the built form in the neighborhood, it's clear that this house is actually one of the longest in the neighborhood and doesn't represent the prevailing character in terms of building length. And it's also been designed to include the tapering of massing towards the side yards, as well as in keeping a limited number of windows on the sides. The property to the north is that of 185 Hannah. It's a 2-story dwelling as well. The front yard and rear yard setbacks are relatively aligned with one another. But I did point out that the existing south yard setback on this property is only 0.53 meters. So we did hear the comments about the limited amount of space that exists between these dwellings today. And then across the street, we see 180 and 182. Again, two-story dwellings with pitched roofs. So this is in the neighborhood's designation of the official plan. I was looking at this from the perspective of the broader and the immediate neighborhood context. In the immediate context, there are 24 properties that are on both sides of HANNA between Parkley and Parkhurst. When I look at this area, I see relatively uniform lot pattern and see that the neighborhood's characterized by dwellings that are 2 stories in height with relatively consistent front yard setbacks. So in terms of the zoning on the property, so we can see that it is the RD zoning, which seeks only single detached dwellings, and then the maximum building length of 17 meters, depth of 19, specifically regulating the floor space index on the property. So in my opinion, is the performance standards that have been adopted here to ensure that modifications to the existing dwellings or new dwellings are compatible with the surrounding neighborhood character. I looked at the history of variance approvals in the immediate neighborhood context. There were 4. They're at 179, 187, 173, and 172. So again, only 2 of these properties actually received increases to the maximum building length, and those were for the 18.41 meters being the greatest. That's at 172 HANNA, and then there is the length at 179 HANNA of 17.92. But overall, my opinion is that we don't see a situation where you see an increase in building length along with increases to maximum main wall height and other variances. The proposal is seeking a 3-story dwelling. Again, 3 stories is permitted, but the 3-story design allows for a GFA of just under 520 meters squared, not including the basement and the garage area. So the variance, we saw the variances that are before you. I had outlined those in my submission. My opinion was the effect of these was to allow a dwelling that exceeds the maximum footprint that's established through the length, depth, and setback regulations, and then it's also allowing a greater main wall height and height that allows for this 3-story massing that increases the FSI, and it's also reducing the side yard setbacks relative to properties that have existing reductions to the side yard setback. So in my opinion, this proposal is not maintaining the general purpose and intent of the official plan. We see the prevailing character is not met. In minor variances that we've seen in the immediate context, there are only 4 of the 24 properties. They do not include reductions to side yard setbacks in conjunction with building length and increases in height. Similarly, with respect to the zoning bylaw, my opinion is that the purpose and intent is not maintained. The regulations for side yards, building length and depth are intended to establish a building footprint. As was noted, this is a large lot that provides considerable amount of space for a large building footprint. So in my opinion, the reductions to the side yards in conjunction with the increase in depth and length do not maintain the purpose and intent of the zoning. It's also not minor in nature.
I'm just going to jump in there.
Not desirable.
Yep, if you ask you to wrap up.
So my opinion is just, in summary, the tests are not met by the variances that are before you.
Okay, thank you. Have any questions? I have a question for you. You in your report you cite concerns with respect to massing, particularly as it relates to the side main wall height and 3rd story. But the agent of the applicant has suggested that the 3rd story is set back from the street, that it in essence is not visible, or it does not kind of impede on the public realm to the extent that, you know, perhaps some opposition is describing. Perhaps you can speak to that for us. And I'd ask, because I mean I am looking. I mean you got to be careful, right? You're looking at the front elevation drawing, but do you, when you pull up the side elevation upon closer examination, we're looking at the third story. I would agree with the applicant that it appears the third story is concealed at the back, and there is a reduction with respect to the front main wall height at the front of the building, which I presume is to ensure consistency or essentially to address the scale and massing of similar properties on the streetscape. So I'm just curious to get your opinion on that matter.
Yes. So what I would say, it's the cumulative impact of the additional length, that additional wall height, the reductions on the side yard setback. So I did hear the comments about there being reduced side yards now relative to what's required. It's not so much just what's compared to what's there now in terms of the side yard. What you're getting is you are getting overall a more massive dwelling through the floor area, through the length of the dwelling, through the depth of the dwelling. So when you get the cumulative impact, there is the opportunity for sure within the design to help bring down those elements to get a less massive and a building of smaller scale that does not need to exceed the permissions that the zoning allow in terms of footprint and building envelope. So again, in my opinion, is while you are taking what's permitted and then pushing those envelopes, again, I think that it's within this context, within the context of the neighborhood character, it really is, when you combine that, instead of just isolating the sidewall height, for example, it's taken into consideration of what that sidewall height in conjunction with reductions to the side setbacks and increases to the overall building length do in terms of the mass and scale of the dwelling. So I'm careful not to isolate the variances and only look at them from that perspective. Certainly this isn't a situation where it's a cube, for example, with that sidewall height extended the entire length of the property. But certainly there is opportunity to bring that sidewall height down, work within the limits of that, and not in conjunction with the length as well.
Okay, thank you. That helps to provide some clarification. There are a number of variances. Is there any specific variances that are of more concern than others, or we're looking at it? My understanding is the cumulative effect of all of the variances. Sorry, maybe I'll pose that as a question for you. Are there particular variances that stand out as a particular concern? Or is it the cumulative effect of all of the variances that are being requested? This is to Mr. Barton. Did we lose him?
Sorry about that. I was unable to mute myself. I think staff have done that now for me. Thank you. There's definitely, I would say, it's the cumulative impact, but the length of the dwelling really does contribute to the overall just massing of the property. So if you were to shorten that length up, inherently it's going to bring down the massing. It's going to reduce the floor area. It's going to reduce the impact of the reductions to the side yard setbacks as well. So I'd say it's a combination of those elements.
Okay, thank you.
Sorry, could I ask a question about the building length? What was the length of 179 again? Do we know that?
179 HANNA Road?
Yes, so I think it was a question directed to me. So it received approval of 17.92.
So, okay. Thank you.
Any other questions of the speaker? Nope. Okay. Moving on to the next speaker. We have some technical difficulties. Okay. Are you with us? Miss Harold, I presume?
Mr. Chair, Amanda Harold keeps muting, so I'm just curious as to whether or not they actually want to speak to this item.
Okay. Perhaps we move on to the next speaker, and if they are listening, perhaps we can get them back on at a later time.
Can folks hear me okay?
We can hear you loud and clear.
Okay, wonderful. I don't know if I'm on camera or not, but I'll thank you for the time. So this is Matt McWhorter at 234 Rumsey Road. I'm representing my wife, Emily Ferrier, and our son. We're at the property, we're one of two properties directly behind the applicant on Rumsey Road. A couple points of context. I would just say that, my wife and I we don't see ourselves as unreasonable people, people that are one to make a fuss. We have good relationships with our neighbors, both on Rumsey Road and on HANNA, to the extent that several of them bought us gifts when we had our first child this past summer. And a couple other points of context I might just call out is I might have missed it, so I do apologize, but I do believe Jay Robinson, our city councillor, also submitted a letter with concerns about this development. And I do want to call out, as some of the other folks from the opposition might, but I'll do it here, is that some of the support letters appear to be quite far away from the 183 HANNA property itself, including two on Vanderhoof Road, which I believe are neighbors of the current owners where they live today. A support letter from a renter, not the homeowner, from across the street on HANNA. And I believe one other individual that is, quite far away from the property itself. But with that context in mind, what I'd like to focus on is my specific opposition and objections. And again, with that context, that we're not difficult people, and we try to not make a fuss and to get along with our neighbors, but we saw this as egregious. First and foremost is just the overall building size being too big for the lot, not on any one dimension, but in combination across all dimensions. We see it as just too big for the lot, even though the lot is materially wider and deeper than most surrounding lots. It's this cumulative number of variances that reinforce why it's too large, including pressure placed on a mature, healthy, 100-year-old silver maple. The overall height and flat roof for us is likely to impair late-day sunlight and negatively impact our enjoyment of our backyard, in addition to impacting our privacy. And again, I'd call out, this is exacerbated by both the height and the depth and length of the building. And I just want to call back to a comment that was made earlier, because I do recognize that the third story is set back from the street on HANNA, which means that it's set towards us. I think coupled with a gently sloping topography of the property downwards towards us further exacerbates the height that we see from the backyard, relative to our property. At 8.85 meters, the main wall height is about 20% greater than what's permitted by the bylaw. Because of this modern architectural design, there's no tapering, and the traditional effect is further exacerbated. The depth and length exceeds both the legacy East York bylaw and the City of Toronto bylaw. The back facade of the home is covered in windows. And so calling back to a previous comment that there were not many windows on both the north and south side setbacks. On the back wall of the home, there are a significant number of windows. Combined with the depth and length of the building, would further encroach on our privacy, would provide unobstructed views into our backyard, and so forth. This is certainly a neighborhood we chose, for its deep backyards and overall privacy. I think the comments around setbacks are, I think, already well understood, but we would reinforce these. We'd call out the potential injury or death to mature trees, especially tree number 3, which is the large 100-year-old silver maple that I mentioned, which provides privacy, shade, and refuge for wildlife. And despite the mitigating factors that were articulated in the arborist report, we feel this tree would suffer irreparable damage. And we also believe that the original estimates of the tree diameter and which trees are protected come from 2021 and were not updated in this most recent year. Go on to say that we've just have general sense that the homeowner is maximizing the property for their own personal enjoyment, at the expense of the neighbor's privacy and quality of life, or perhaps to maximize the value of the property for a subsequent sale. Just the cumulative number of variances and their materiality just give that sense. Why would we need 9 variances that are each materially over what the threshold is? And then in summary, I would just say that, we believe that these are categorically not minor variances. There's 9 in total. The agent for the applicant referenced that this was further reduced from an original plan. So I can only imagine what the total dimensions were at that point. And so in aggregate, we feel these variances are excessive at face value and not minor. And I used language of abusive in my letter, which I do not believe is too strong. So in summary, I just implore the committee to recognize the vocal opposition of not just 1 or 2 neighbors, but I believe 20 letters of opposition, including our city councilor and the Leaside Residents Association, and to reject all variances and consider a future application when these have been addressed.
Okay.
Thank you very much for listening.
Okay, thank you. Any questions? Okay. We have our next speaker with us. Oh, of course. I don't believe, do we have Ms. Harold?
Mr. Chair, if I may, before we move on, so Matthew McWhirter spoke from 234 Rumsey, I believe. There's also an Emily Fairview that he had mentioned. I'm not sure if they're the same residents or if she's given an opportunity to speak too.
I have them both listed under the same address.
Okay. Maybe we should just check in quickly.
Yeah, if we can. I will state in advance, in a general sense, we tend to allocate a presentation, based on a household unit. So, but I would like to check in with that person to verify that information.
It's no problem at all. It's Matt here. I was speaking on both of our behalf. So Emily is just listening in. So thank you for the consideration.
Okay, and thank you for the clarification. Okay. I mean, in no particular order. Would it help if I just call on specific speakers? Sure. Okay. Is Mr. Harris with us?
Actually, sorry, Mr. Chair,
yeah.
If I may. So Lawrence Jordan, or Jordan Lawrence, I'm not entirely sure which way that's supposed to be, was supposed to be in person. However, I do see them online.
Very good. Yeah, if we can hear from Mr. Jordan.
Am I coming through?
We can hear you.
Perfect. Thank you, everyone, giving me the opportunity to speak this morning. So just for context, I've been hearing a lot of information around variances.
I'm going to interrupt. If you can just give us your address.
Oh, of course.
Yeah.
So Lawrence Jordan, 171 Hannah Road.
Okay, thank you. You may proceed.
So I'm thank you. I just want to give a little bit of perspective because I think there's a lot of great information, a lot of research and that people have done. And so they're probably going to be a little bit better, more articulate with their views and opinions on the property and the applicant. One of the observations, so just for awareness, so I'm a third generation Jordan living at 171. So I've seen a lot of the renovations and rebuilds within the street of the neighborhood. So I've been coming to this neighborhood for about 50 years. So one of the things that I'm very curious about, because I know Larry Swartz had mentioned that earlier about consultation with neighbors and the properties. And I know it's not under the purview of the committee, but I was not consulted or aware of what was being built or how it was being built. And so I think going back to that kind of statement or comments, I think it might be a little bit more prudent to understand what's being built and the design elements of the house. And just on the design elements, if you look around the street itself of previous rebuilds, there's a lot of beautiful homes. And they've kept with that kind of architectural style of what Lee's Side was built back in the 30s and 40s. And it's as a homeowner on the street, you're proud of what those builds have done. And so when you talk about incremental trends of where architecture is going, the view seems to be somewhat subjective in my view, because if you go back around the neighborhood about some of the areas and rebuilds that have occurred have happened, you can go back 20 years ago and when rebuilds were happening, it seems like every house was putting up plaster in every color of seagull gray or almond. And I don't want to say that was an architectural trend back in the 2000s and that's where things were going. So again, that's just a more of a subjective view and opinion on my part. But again, the general lot pattern, what we would call in statistics, is an outlier. And so when we're trying to compare apples to apples, it's more like we're comparing apples to pineapples. So it is much larger and there is that kind of consideration. And I think there's a lot better experts within this context to give a better direction of what should be allowed or not be allowed. So I just want to call out those kind of few things. And again, it's just my view and opinion on that. And obviously I would like to speak to the neighbors, and now I would love to have them build a beautiful home and house on that property and help them support them to do that. Thank you.
Okay, thank you. Any questions?
Yeah, he is again.
Okay, thank you.
Hello?
Hello. Who do we have with us?
Mark Pittman at 173 Hannah Road. My neighbor, Lawrence Jordan, was just speaking to you, and I've also been in contact with my neighbor on Rumsey, Matt McWilter. So I'm speaking on behalf of myself as a homeowner and my wife, Adele, and we are objecting to the overall, concept of this bill. It is totally out of character for the area. The mass, notwithstanding that the lot size is, of course, bigger than the normal here, is just too much. That's our opinion, and I'll let others more capable of speaking to the actual variances do that. And so things like that. And I'm sorry, I may be rambling a little bit. So let me just go back so we object to the total mass. And if you look down our street, and Lawrence raised a good point as far as the beautiful nature of a lot of the houses, including the renovations that people have done. It fits in, it flows, it looks very nice. This would end up being an apartment building, a concrete block, in my opinion. And it looks that way. In the limited drawings that or pictures that we've seen, it doesn't have any aesthetic value, that, in my opinion. Anyways, the cumulative effect of all the variances on this lot would be massive. The other things that I think when we did our reno, we went around and consulted with all our neighbors that were directly in connection, and you know, what we heard from the original presentation of the applicant was that they went around. We weren't consulted. We never heard anything from them. I guess the other thing too is that I know Matt spoke to some of the support letters. The one thing that he did not mention is that, and I believe Brian Harris, who now lives at 182, is that one of the support letters was from the former owner directly across from 183. Just keep that in mind, please. I don't think I have anything else that I can say, except that, you know, as I say, I cannot speak to the variances as well as other people can. And it's, from our point of view, it's the aesthetics that we are really objecting to mostly. And the size of it, it's massive.
Okay.
And more the impact it's going to have on our neighbors surrounding. Yeah. Thank you. Any questions? Please let me know.
Thank you. Thank you. Any questions? Okay. Have any other speakers on the line?
Hi, it looks like I've been unmuted. My name is Brian Harris, and I'm at 182 Hannah Road.
Good morning,
Thank you
Mr.
for all your
Harris.
time this morning. Good morning. The first, I guess, point I'd like to make is, since I'm now the current owner of 182 Hannah Road, I propose that the previous letter of support be overridden by my letter of objection. And overall, my concern is the cumulative variances will be extremely impactful on all the existing neighbors, including myself being directly across the street from them. And having, as other people have noted, having an already extremely large lot size does not constitute the, you know, requirement to impose other variances. They have the ability to build a large, beautiful home in the existing footprint or the existing lot without imposing any additional variances. And overall, outside of that, I don't think anything this large needs to be built there. It doesn't fit with the street, and it's going to be, you know, imposing on all surrounding properties, potentially impacting their value and the use that everyone of the properties on the street. And that's all. Thank you very much.
Okay, thank you. Are there any questions? No questions. Okay. I am seeing a speaker from 167 Hannah Road. I'm not sure if we have them with us, as well as 37 Parkley Drive.
I am here. I'm Jennifer McGlashan. I'm at 167 Hannah Road. I speak on behalf of my husband, Soren Popescu. He's also an architect, and I'm a lawyer at Super and Company. And we were not consulted with respect to the variances that are being proposed by 183. In fact, it was brought to our attention by our neighbors as to what these type of variances would be. I have not read, or nor have I heard, as to whether the applicant has actually satisfied the onus of meeting before tasks established under the Planning Act. In addition, I have not seen or read of any shadow report that has been actually completed by the applicant. Clearly, there are neighbors here who have concerns as to the lighting and how this will be obstructive with respect to all these variances. It will result in a massive dwelling. And so I feel that that is important and that should be requested here. And second of all, I would also like to speak about the irrigation. The fact that we do have beautiful trees here in Leaside. And if you take any one of those trees, as well as increase the footprint of any existing structure on any property, it will result in overflow of water with respect to neighboring properties. There's already a pooling of water that occurs naturally at Hannah and Parkley Road. Now, this is a very high traffic area of pedestrians because it is very close to the Leaside High School. And, that is something of concern that the city has been trying to routinely address. But to allow this size of a footprint with respect to this variance and also eliminate any trees with respect to this property will mean that the neighboring properties will then have to face the irrigation. And this cannot be resolved with respect to them installing a slump pump. If they were to install a slump pump, that resolves the issue with respect to their properties, but it doesn't resolve the issues with respect to the neighboring properties. That's all I like to say.
Okay, thank you. Any questions? None? Okay, I believe we have one more speaker.
Mr. Chair, I tried to reach out to Amanda. I called the number and I got her voicemail.
Okay, thank you. I'll ask one more time. No questions at this time. I'm going to ask the agent to come back.
Mr. Chair, was there?
Of course.
There was a
Yes,
person
please
who
come
wanted to
down.
speak.
Yes, and you asked to speak last. $185 Hannah Road, I believe.
That is correct.
Yeah,
Thank-
185. That's very
If you could just state both of your names as well.
David Sprague.
Catherine Bowman.
Thank you. Just to remind you guys, 5 minutes on the clock, and the floor is yours.
Okay, I'd like to thank the opposition people that have made comments. They've taken away much of my thunder, which hopefully will keep me short. Ms. Eisen brought up two questions, or two issues. One was, one was massing, and one was consultation. And I know that in some ways those really aren't the purview, but given that they have been raised by the applicant, I'd like to respond. The applicants have had very poor consultation. They dropped by 185 in the late spring and said they'd like to talk. Kath was not available, and we said, okay, I'll call you back and let's set up a time. I looked at my records. I called them back on June the 18th to the number that they gave me, got a message, and I have heard zero back from them. There's talk about another application. We heard nothing about that application. So we've had no chance to do that. Kath and I did travel during the summer, but we were both available by phone at any point, and they did not come back to us. I have, the only time they did come back to us was, I think they came back to Kath 2 or 3 days after the application was mailed out to us, so about a week and a half ago. So that's not consultation. The number of objections speaks volumes about the lack of openness and willingness to work with the neighbors. There's fierce opposition because of the whole cumulative effect of 9. To pick at one or the other of the things is almost impossible. There's also a number of inaccuracies in the applicant's material. Several problems with the support letters, talking about people that were tenants and etc. It's already been covered. They misrepresented the space between 183 and 185 as shown in the incorrect picture, which we had to correct. They were dated, the support letters were all dated in June 2023 before the application was made, so that the people that are supporting had no idea, in effect, what they were supporting. And this is a totally different application. The number is even a different one. So the support letters should be dropped out. The arborist's inventory of trees is 2 years old. Trees do grow. And I think the people have made some very good comments about that. The supplement, the page 9 of the supplemental material, I'd like my wife, Kath, to take over now. Thank you.
So the, the applicant quite kindly provided pictures of a number of homes in the area. Unfortunately, we don't believe that that is a true representation of the comparison of this proposed build to the home. So if you look at the second last page of the supplemental material, keep going, second last page with the picture. It shows the proposed build in relation to the two adjoining properties, our own and 179. It also shows a tree on the front yard. Yet their building plan shows that that tree is, no, that's not it. It's this picture. So it's the picture that shows, it's an artist rendering. Well, that sort of shows it. But it's not, there's a tree shown on the front lawn, which would soften the impact. That tree is being removed. Their plan says that it's being removed. It also shows that the height is not accurate. It shows that the height of that's the one I was talking about. That tree is being removed. The hedge that's between our two properties, 185 and 183, is on their side, and we believe it's going to be removed. It shows that the height is comparable to ours. That's not true. They're requesting a height variance, so it's going to be higher. So again, it's been stressed, and I can't emphasize enough, this is a 50-foot lot. They're asking for variances on both sides, as well as height and length. I dispute saying that you can't see the third floor from the street. I believe you will see the third floor, and there will be nothing to hide it. In addition, I believe that they are going to, although they've asked for a permit to injure that tree in the back, I think that will kill. If you look at the plans and they're going to be digging through that root system, I think that will lead to the eventual death of that tree. And that will severely impact our enjoyment of our property, our sunshine, our privacy. And so we respectfully request that all these variances be denied.
Okay, thank you. I have a question for you. With respect to front main wall height, you've made an observation comparing the building on your property to the application. Do you, just by comparison, do you know offhand what the front main wall height is on the adjacent building on your property?
No, I'm afraid I don't, but I know that we have a roof, and this is going to be a completely flat, although it will slope back. So no, I'm afraid I can't answer that. Maybe my husband.
I can't give you, we're 2-story normal 8-foot ceiling, so it's not super high. Is the best
I'm just trying to understand. I mean, you've made a statement that the scale is essentially what I think you're referring to as the front main wall is out of proportion in relation to your building, and I'm just trying to maybe get a quantitative comparison of those heights to better understand how they might differ.
I understand. I think even in the pictures that they have shown, if they can go to page 6, where it shows the build in between our houses. Page 6, counting backwards. The applicant may know which one it is. That one. So they have, oh, this one? Okay. Sorry, she found it.
Thank you.
You'll see that they have shrunk the size of that house and made it look like our house is bigger. That's not the case. And I know why they've done it. They've done it to make it look right, look nice, but you're comparing a rendering, which is not to scale, to pictures of houses. And I think it gives the wrong impression. And I would say the same thing for all of the other pictures that have been submitted, which are on normal Leaside size lots. And they're comparing their 50-foot lot and a maximum width on a 50-foot lot to our normal size 30 lots. And I think that's gives the wrong impression.
Okay, I am trying to get as much accurate information as I can. I do recognize that, you know, sometimes when you're putting a rendering next to a picture, there might be a slight issue with the scale, and I am going to ask the same question of the agent with respect to understanding the front main wall height along the street. Because frankly, I mean, if I may, it appears to me that when we're looking specifically at the front main wall, that they are more or less, or I should say generally in line. And I might also extend that with respect to the slope. But I would like some clarification on that. So, and perhaps we may get that from the agent, but if there's anything else you'd like to speak to that, specifically that question, I would be, my ears are open.
If I could speak just very briefly. We're 2 stories. We go up approximately 20 feet to the roof of the second story, plus a little bit for the basement, so 22 feet.
Fair enough.
And then we have a sloping roof that goes up. But I was just going to make the comment in terms of you talk about the massing. I think that if you look at the current picture, which is there somewhere, you'll see that, and Ms. Eisen mentioned that, we're not changing that very much. It's just as wide as what's there. I would suggest that what's there is a 50s abomination, and it's a bit of a mistake to allow the extra widths, because they have a chance to do it right and make it look like a Leaside house, not something that had an add-on garage. Thank you. Okay.
The photo submitted to show the posting of the notice is an excellent picture of the current standing and how it shows. It's on two different levels. It's the one I believe that was posted, not the first photo that was posted, but the second photo that was posted showing the location of the notice on the front of the existing building. And it shows the character and how it was broken up, but it also shows the relationship of the existing building.
Okay. One more quick question. Do you happen to know what the setback is on your property from the?
Yes, I do. It's quite narrow.
You're talking on the south side?
Um,
I'm asking about your setback to the property line.
So it ranges from 0.46 at the most easterly end, and the biggest setback is 0.76 up at the front.
And we're, just to be clear, we're talking about 185.
185, the building on the left here.
Mm-hmm. Yep.
So at the front, our property setback is 0.76, and it narrows to 0.49 where our chimney is, and it's 0.39 at the second chimney, at 0.53 before our which is part of the original build, but it looks like an extension. It's not. It was original build. That was 0.53, and then it narrows to 0.46. And all of this is located on the survey that was submitted by the applicant.
And would you say that setback is reflective of the character within prevailing setbacks within the area? Because you did note that the setback is actually, the side yard setback at 185 is actually less than what's being proposed, if I'm not mistaken, at 183.
We've been in our house for 43 years.
Yeah.
It's never been renovated. I think it was built in the 1940s. And it's got a driveway on the other side. And so it doesn't take up the full width of our lot. So whether it's typical of that age, I don't know. I know that what the current requirements are, and I think as has already been stated, this is a very large lot, and there's no reason that they require variances to build still a lovely, large, imposing structure, but they don't need the variances to do it. And we know that that's the only thing that's the purview of this committee is the variance request. And so that's why we are requesting that it be denied.
And you are correct in making that statement. So I thank you for that. Okay, are there any other questions, Mr. Auspitz?
Sorry, I noticed, so I just want to clarify. So the setbacks are reduced on the side closest to 183, but on the other side of your lot, you do have a larger setback, correct?
We have a driveway.
Yes. Okay. And that driveway width, I think, goes right through, correct?
Yes, we have a separate garage, which is shown on the survey there.
Okay. And so a driveway width, my understanding, would probably have to be about 3 meters around typically?
Approximately, yes.
Okay.
I can get I used to be able to get a very large car and a trailer back there, but I can't anymore.
Oh, no. Okay, thanks very much. That really helps, and yeah, thanks.
Okay. I thank you for that question because you do raise a point that while they may have a certain setback on one side, they are affording a larger setback on the other side. Any other questions? Okay.
Sorry.
No, I don't have a question, but I'm ready to bring a motion.
Mr. Chair, the applicant needs to respond to the neighbors.
Yes. I will note that we are breached the 1 hour mark on this, but I do recognize that we do have a large number of speakers to this this file. So I mean, I will do my best to keep it moving. So if we could have the agent back. Thank you very much. If we could have the agent back to speak specifically to some of the objections that were raised with the other speakers. The floor is yours.
Thank you. In the interim, we emailed a letter that the applicants had left in the mailboxes of the neighbors. If staff is able to pull that up, I just clarified with them. They went around the neighborhood, about 4 or 5 houses from the stop sign up HANNA, on both sides of HANNA and also in Rumsey. Left a letter in mailboxes of the people that weren't home, spoke to everyone who was home, and the letter had their phone number on it and basically said, we're building, we want to review our plans with you, please contact us at any time. In addition to that, they spoke to some of the neighbors that came here in opposition today, one of which I'm not going to name, but he told them that he had no issues whatsoever. He just didn't want to go on record signing a letter of support, and then came out in opposition. And there are other examples of that as well. So contact attempts were made. They made it known that they were approachable, and left their contact information. I also want to add that this is a family coming from within Leaside. They're upstanding Leaside citizens and have been in the neighborhood for 15 years and respect the character of the neighborhood and the integrity of the neighborhood, as many of the people in objection noted today. I think that this home has been painted as a very large, egregious ask of something that comes out all the way to the exception of the setbacks, all the way up to the exception of that main sidewall height. I heard words today, concrete block, apartment building, extruded cube, whereas so much effort has been put into to mirroring the prevailing physical characteristics of the neighborhood. We've been focused on what we're proposing, and a lot of the residents in opposition have focused on what they don't want in the neighborhood. But I also want to bring it back to what's there existing. I have a page of that if you want to go to it. Actually, I have a couple of questions to answer as well. But the existing house has the 2-car driveway with the reduced soft landscape. It is a 3-story home existing on 183 HANNA. The north setback is significantly smaller than what's allowed and even smaller than what we're proposing. The height of the existing house is already 8.85 meters. We are not exceeding the height, and it is shorter and will be shorter than the house to the north at 185, thank you, Hannah. And the proposed house doesn't have an effect on the conditions of the streetscape, the light, or the spacing. We are under on lot coverage, and I also heard comments about the footprint of the house. The footprint is under the 17 meters in length. The additional length that we're asking for is in the form of the cantilever. So with respect to drainage or anything there's it's not outside of what's permitted. Also, comments on the tree. We worked very closely with urban forestry to preserve the old silver maple in the rear of the house. We designed the massing and redesigned the basement walkout a couple times in such a way to be mostly outside of the TPZ. Not only is it important to us because of the age, size of the tree, the drainage, and so many other issues that were brought up, but the tree is also going to provide a lot of privacy for the homeowners and for the surrounding neighborhood. We contracted Central Tree Care, which is one of the top arborists in the city, and have been through a supervised exploratory route exploration, working together for over 1 year really to ensure the success of this tree because it's absolutely a priority. So ultimately, this is a proposal that's been designed with the utmost respect to the neighborhood, with the feedback from the original letters of opposition from the spring in mind, and with respect of the official plan and the zoning bylaws. I believe it's contextual and it carries the same front setback and roof line and language as the surrounding homes, and I actually have those numbers for you on the front wall height and the roof heights if you'd like. The proposed house is not only identical to the existing house in terms of its impact to the street, the neighborhood, and the immediate neighbors, but it mirrors the physical characteristics and really respects the Leaside side vernacular. And ultimately, I think that the city planning staff said it best when they noted that it is mostly within the zoning bylaws. So I truly feel that this proposal easily meets each of the 4 tests, and I hope that you will find it does as well.
Thank you. Any questions?
Through you, Mr. Chair, question to the applicant about the tree in the front yard. Is that being retained?
The tree in the front yard, we have an application to remove it. It will be replaced with a lot of beautiful soft landscaping, including additional trees. It's the location of the tree that poses an issue.
Thank you.
Any other questions? Okay, thank you, Ms. Eisen. Are we prepared to move into committee? You're getting ready for a motion, but I think this it warrants just a little bit of discussion. I know we've allocated a lot of time, but a lot of things have been raised here, and I think frankly I would like to hear from other members on the committee what they think about what we've heard today. So I will open up the floor for discussion.
I think the two big issues are one is relevant, one is probably not as relevant, but does have some merit with respect to intent of the bylaw. Are overall, like the size, mass, scale of the dwelling. I guess there was, and probably the second is I'm wondering if architectural design like fed into some of this, even though it's not relevant to the decision. I think in terms of, I think there are some issues. For example, increasing the building height on the walls. I think that's related to, like, I mean, I think the intent of having 2 separate building heights in terms of meeting the intent of the zoning bylaw is to allow for certain pitches with respect to roofs. I see that there is a sloped roof kind of proposed, but I don't know if that necessarily meets the intent of the zoning bylaw for having the 2 heights. But I'm not. I'd like to hear more on that.
I mean, I'd like to perhaps speak just briefly to the side main wall. I think the condition is, it's really a condition of, you know, it's a condition of the style of roof, really. I mean, there's a lot of homes on the street, and I mean, I got a little bit of experience with this, you know, in East York, where we have, you know, a 2-story main wall sloping up to a third, and we get those side main walls, I should say, on the side. I mean, the alternative is, you know, a pitched roof where you're sloping down on the sides, but that's just not what this building is. It's not what the typology is, and I don't have a concern because there are other precedents on the street with similar sloped roofs that are afforded similar side main wall heights. They go right up. It does not, for example, you know, the neighbor at, I believe, 185, right? They've got it's a 2-story main wall. It's pretty modest, right? But that roof slopes up. The side main walls slope up with it. It's not 2 stories around the entire building. They are afforded a 3-story side main wall on the side as this application is proposing. So perhaps worth pointing that out.
I have a question. If the applicant had put trim on, right? I'm not redesigning, but if the applicant had shown trim on the architectural elevation where the roof slopes up, I'm wondering if there would be fewer people speaking in terms of context.
Well, I think this comes to your observation about, whether this is this can quickly veer off into design, right? And I recognize that, character and fit are part of the official plan. I do acknowledge that the applicant, the agent here, it's a modern building, but the massing, right? The massing quite, generally is very similar to other buildings on the street. It's a modern building, so for that reason, I think, to a layperson, it can be quite deceiving. But for me, I mean, the thing that I'm paying attention to is the front main wall height, right, in relationship to the adjacent buildings. I don't have any issue with the side main walls because they're at the back. They slope up with a pitched roof like the neighboring houses do. And I think that's actually very common in this area, both in the immediate and broader context. So the side main wall height is not so much a concern. I think it would be more of a concern, and we see this in a lot of applications, where that side main wall is carried through around the entire building, In this case, it's at the side, it's at the back, and it's mitigated through a pitched roof off of a two-story front main wall, so.
I agree. I just wanted to point it out that I think that's probably a source of some of the objection, and I think it needed to come forward in that discussion.
Yes, of course, yeah.
The other point I want to raise is I do have concerns with respect to interior side yard reductions. It's the width of the lot is much wider than anything in the surrounding context. I think at least on one side, the interior side yard setback should be maintained, at least, if not both. Probably in this case, both.
And that's based on your observation that it is just a wider lot? Because I asked this of one of the speakers with respect to their side yard setback. They actually have a smaller side yard setback in relation to what the applicant is proposing.
I think it is in relation to the wider lot, and I think in terms of the width of the dwelling, it might look out of place having several lots that are narrower in width. Adjacent dwell, and when I did ask about, I think it's adjacent dwelling at 185 HANNA, it does have a reduced interior side yard setback on one side, but they also have a driveway on the other side along the interior side yard. So I think the width of this dwelling would be out of place with the reduced side yard setbacks. I think one of the side yards at least should be met.
Which side yard? We've got two variances. There's a north and a south. I presume you're speaking to the north, which is adjacent to the neighbor at 185, if I'm not mistaken.
I think that would probably be better, just because it would allow for appropriate spacing between the dwellings.
Okay. Any other comments?
Do you want me to make my comments now or with my motion?
If you're ready,
if I'm ready,
go for it. But I'd like to hear your thoughts.
My comments first before I make the motion, because you can then discuss them, or you can discuss them after my motion, whatever you.
Perhaps your comments first, then, given the nature of this.
Okay, so my comments. So I'm looking at the Planning Act and the 4 tests, right? And I guess the first one is whether this is minor. And we've had some representations saying, well, taken in context, all in total, there are 9 requests. That's not minor. And we've got a report from a planner that says it's not minor. So I think...
Can we just pull that report up?
Well, can I pull it? It's MB1, right? preliminary planning review?
Not, it's not a staff report, it's from,
That's from
it's a consultant report.
consultant report, right? So I'm just dealing with, I mean, there's 4 tests, right? So I want to deal with the 4 tests. So the minor issue, I mean, there wasn't a strong objection by the city, but there is a planning experts report that says these aren't minor. So I tend to give some weight to an independent planning expert. It's up to us to decide whether it's sufficient, but we've heard from the submissions by the members of the public that they don't consider all of this minor in total. When you hear so many people from the public, plus you have an expert report, I think you have to give it some weight. So I would give it some weight, but I want to move on to some of the other tests, right? So then the general intent and purpose of the bylaw and the general intent and purpose of the official plan. I think maybe what we're struggling with is maybe there's really not anything that says that there's, I mean, there is some submission. There is a lawyer's letter talking about the general intent and purpose of the bylaw, general intent and purpose of official plan. I'm not convinced there's a fence. I'm more concerned about the minor variance taken as a whole, 9, and with an expert report and significant opposition from the public. But where I want to focus in on of the 4 tests is the desirability for the appropriate development of the land use. And so there I've broken it down into a couple components. It's not 100% clear cut, but I think on balance, it's not desirable. And here's why. So I think that the key reason why I would consider this not desirable is because of the unique characteristics of this lot. This is a big lot. There are a bunch of smaller lots on that street. They tend to look more or less the same. There's been some new development. I took a look at Google Maps to see what the street looks like. Here you have a proposed building on the largest lot on the street that looks different in size, and it just doesn't really fit in. So when you think about the unique site characteristics, it doesn't fit in at the beginning because it's a bigger lot, and it's going to fit in even less based on all these proposals for minor variances. So I think taken as a whole, it ties back to what I said about the minor variances. I don't think it's minor because if you combine the minorness with the desirability and you look at the uniqueness of that lot, it's not minor. But then even if you break down further what's going on in terms of the desirability, so I said the unique site characteristics I don't consider to be desirable in these circumstances. Although there is some desirability here, and I think that may be what we're struggling with. Maybe I should address that, some of the desirability, at least for the benefit of the applicant. So I believe that so here's the good things about it from a desirability point of view. It's going to enhance the functionality of that particular site. It's going to be a better house. It's going to be a new house. It's going to give somebody pleasure by living there. That is a positive thing, and I think that the applicant has, although maybe not so specifically, has articulated that to some extent, saying that people are in the neighborhood, they're coming there, and I think that is a positive thing that, in terms of desirability, I think that's a positive thing. But I think that there are other undesirable things that outweigh that. The first one I already addressed, which is the size of the size of the lot and the nature of how it's going to be on the street, the unique characteristics. There's public interest in terms of desirability. I don't think we can just say that so many people opposing this are just wrong, just plain wrong because the Planning Act doesn't address that. I think that goes into the desirability. I think that they sense innately that there's something wrong here, and I think they're right. And I think they're right because it's not promoting the responsible development for this particular site. Aesthetics and design, we don't really tend to get into them so much, but some people have mentioned them. I don't really want to say what my design preferences are, but I think if you've got some aesthetic issues with property and you want to deal with desirability, they ought to be pretty positive. And in this case, I don't see that they're pretty positive. At least they're debatable. So that doesn't provide anything that I would say would lead to me saying that it's desirable. And then you look at the harmony and character. Well, that goes somewhat to design. And again, we're not seeing something positive. What you do see positive from the applicant is enhancing the functionality. What you might see, well, here's another thing, the economic and social benefits, right? So there's economics and social benefit to maybe one person or one owner, but there's no overwhelming economic or social benefit that would tend to say, well, this is desirable or appropriate. So there's nothing there. So I would say on balance, if you're looking at the desirability, given that it's a unique characteristic of this lot, there's nothing here that particularly addresses it. In fact, it takes it in the opposite direction. There's really no overwhelming desirability other than the functionality for one party, and then there's a whole bunch of questions, including the unique characteristics of this site. So for all those reasons, and taking that, tying it into the minor, I would vote against this. I would refuse it. Let them come back. Either they can appeal it or go back to the residents and come back with a better design. It ought to be, it's a big piece of property. And as one of the other residents already said, they could do this without any variances. Well, I don't think they should have to do it without any variances. I think they can have some variances if they're minor. I don't think these are minor, so I would refuse.
Is there particular variances that stand out of concern? Because, I mean, there are some things, there are variances that I may disagree on, but
I've heard some comments from some of the members of the panel, and I tend to agree with those, but I think it's the overall nature. I think that if there was something that was more of addressing the unique characteristics of this property, being large, and trying to put it in a scale that is more pleasing to the other properties, then I would have accepted it, because I am sensitive to the fact that they are enhancing the functionality of this this property, and I'd like to see it done in a way that addresses the unique site characteristics, has more sensitivity to the public interest, is more compatible to the surrounding, and has better aesthetics. I don't think it meets all those, so on balance, I'd have to say it's not desirable, and it's not desirable in a combination not being desirable and not being minor.
do we have a motion with that?
Well, I'm prepared to bring my motion.
I mean, I haven't heard from Mr., but we may not.
It's a tough one to decide.
Before motions make that.
Mike.
Is this, I know this the decision has been deferred once. And I know that there is some comments coming, there's some comments coming forward, and I think architectural design is feeding into a lot of this. Is this something that could potentially be deferred again? I don't want to get to it, I don't know how everyone is going to vote, but I don't want to get, I would prefer if we didn't need to get to a decision at this time.
Maybe it's for the applicant. If the applicant wants to defer it, then
before I do that, I'm going to look over to the Secretary Treasurer, just given the fact that we've deliberated over this for
Mr. Chair, the decision to defer is in your hands, but be mindful that we've heard over an hour of evidence.
That's right. Yeah,
maybe more so to a courtesy of the neighbors who have taken the time to appear and write letters.
Yeah, I mean, just given the fact that we are seconds from a motion on this I just don't think would be in keeping with our policy and procedure, but I certainly would encourage, it's certainly not outside the realm of possibility that this application can continue to move in the right direction. If it was refused today, it's not to say that they wouldn't be able to come back and address some of the comments that were heard today. Do we have a motion?
I'm prepared to bring it.
Okay.
You know what it's going
All
to be.
right.
So I'd bring my motion to refuse the application on the basis that I do not consider it, or the committee does not consider it to meet the 4 tests under the Planning Act, and that, as previously stated, not being minor and not desirable for the appropriate development of the use of the land.
And do we have a second to that motion? We don't have a seconder? If we don't have a seconder, the motion fails. We have another motion. I'm looking to you, Mr. Auspitz, because you were the other person that was willing to bring a motion. But you do have to,
Sorry.
we do have to, it will be put to a vote.
I mean, for the reasons that I noted, I mean, I would like to motion to defer.
Do we have a seconder to that?
Sure, I'll
I
second it.
that. What can we do? Can we put a motion?
I'm going to pull this out of committee for a minute and just check with the Secretary Treasurer. I mean, even though I've spoken about, deferring this kind of late in the process, I mean, ultimately, if the...
Mr. Chair, if you're going to move a motion to defer, you should allow the applicant an opportunity to address your deferral motion.
Thank you. Yes, I would agree. That is appropriate. So I'm going to, we're at a committee now, so I apologize. I know this has taken a long time, but I want to make sure that this is done correctly. If I can have the applicant speak to the motion for deferral, see whether or not that would be amenable at this time.
If I may also comment on one thing I heard earlier, I would also be open to a motion that's conditional upon the elimination of one side setback, if that is amenable to you. Although we'd probably like to choose which one, but if you prefer to state which one, that I would be open to that.
I think he was referring to the north side yard setback. Is that correct, Mr. Auspitz?
That is correct.
So if there's a motion to approve that's conditional upon the elimination of that variance, I would be open to that as well. I think that might be a path forward. Alternatively, if there is no possibility of a motion to approve, then we would prefer a deferral rather than a rejection.
Okay, thank you very much. Are there any questions before we go back into committee? No questions? Okay, let's move back into committee.
Mr. Chair, just to clarify, if a motion is contemplated and a variance is not supported, the member would specifically reference the variance number that is going to be refused. So if you are contemplating approving the application, but not approve one or two of the variances, you would specifically have to mention in your motion or the member's motion which variance is being refused.
Right. I mean, at this time, we just have one motion that did not go anywhere. But I guess I'm waiting to see if there's another motion from someone else on the committee.
I think we have to still vote on my motion.
Right. That was to your comment. Thank you.
It's just two.
And I apologize. So would you restate the motion for us?
My original motion was to defer.
Thank you. Yes.
And I said,
Mr. Chair, I need a reason for deferral.
To allow the applicant to address public comments related to the application.
Okay, do we have a seconder for the motion to defer?
That I did, but I do.
We have a second by Mr. Schwartz. All in favor? Okay, Mr. Moziani is in favor. All opposed? Myself and Ms. Casson are opposed. Okay, the motion carries. The application is deferred.
Thank you for your time. See you again.
Okay, I think it's appropriate to take a break at this time. I realize we are running a little bit behind, and I will make an effort to get us back on track. I'm looking to other members and staff. Would 10 minutes suffice, or should we take an additional 5, 10?
10 is good. 10 is good. Yeah.
Staff, yes? Okay. Let's take a 10-minute break and resume at 12:28 p.m. Okay, if everybody's back, we are going to resume. So item number 4 has been deferred, which will allow us to move on to item number 5. Number 346 Cranbrookhe Avenue. The purpose of the application is to construct an outdoor covered deck with a seating/eating area, an outdoor 2-piece bathroom and storage room, as well. The existing detached garage in the rear is to be demolished as part of that application. And I have variances for lot coverage, as two variances for lot coverage, one specifically with respect to lot coverage of an ancillary building. I have submission material from the applicant, as well as a letter of objection from 344, thank you, 344 Cranbrookhe Avenue, memorandum from Urban Forestry, staff report from Community Planning, as well as a previous C of A submission. Do we have the agent with us? Good morning. Thank you for your patience this morning. Could you please state your name and address for the record?
Good morning. My name is Bijan Levine, Custom Renovations and Design. My address is 14845 Yonge Street, and I'm with Jonathan Minsky, owner of 346 Cranbrookhe.
Okay. And are both of you speaking today, or?
If needed.
Yeah. Okay. I'm going to ask for a brief presentation.
Sure.
Whenever you're ready.
Okay. So we are proposing to build a covered deck in the rear of the property facing the house. So if you're sitting in the kitchen looking out the window, you have the deck looking back at you. The purpose of the structure is to provide a better outdoor living space for Jonathan and his wife and his 2 kids. In the back, there will be a very small outdoor bathroom, approximately 20 square feet, and a storage area along the back of the actual unit. So the variances that we're talking about are the size of the actual structure, which would be slightly more than is allowed. But the purpose of the structure is to be able to have, as well as the storage and the bathroom, to be able to have a small dining covered area and a small seating area out there. So making this any smaller than it is will render one of those 2 items non-functional. So we are asking the committee to give us exception on the variance for that. And in terms of the actual coverage of the lot itself, we are planning on putting a 6-foot by 6-foot gravel pit to accommodate drainage. And if need be, we can also run a sump pump all the way out to the front of the property. So drainage will not be an issue.
Okay. Okay, thank you.
Thank you.
Do you have any questions before? I believe we have another speaker in person. If you can come down to the podium and state your name and address for us, please.
Hi, that's Elena Ravens, and the address is 344 Cranbrookhe Avenue.
Welcome.
I am the neighbor to the east.
Okay.
So if I can ask you, first of all, thank you for giving me this opportunity to voice my concerns or whatever. Can you please bring up the site plan on the screen? So the properties are very narrow. They are only 25 feet. Momentarily, so I'm the property on the right-hand side as you're looking at the plan. Momentarily, to create privacy between the 2 properties, which the houses are virtually this far apart. We 33 years ago with the neighbor agreed on planting a hedge between us, which is now about 8 foot tall. And it was planted on the property line, eventually spreads, and it's fair size. So that gives us the privacy. The green area, as it's indicated there, isn't really green. 16 feet, 4.3 meters from the back of the house, Jonathan and his family have a concrete patio. So the amount of greenery that would be left between the new seating area and the patio is exactly 3.6 meters. So there is no tree, there is no other greenery. The only tree which is in the neighborhood I provide, which is on my property, but generally on right upper corner of this site plan, there's the picture. It's a large tree with the branches reaching into Jonathan's backyard and all that, but it's virtually the only large tree. The picture is taken a week ago, so it doesn't have any leaves. If the construction is built, and the tree is, I would say, 14, 16 inches diameter of the trunk. If the construction go ahead, that tree will be damaged. There is no way to build it because the branches are going onto his property. This is an interesting thing because this is calling for an ancillary building, which I don't believe that outdoor seating and a washroom is ancillary. It's a building, and therefore it should not be located 460 millimeters from my property. This building that's being proposed goes from a property line to property line. So I don't know what the plan with the hedges is, but the building is simply way oversized to the property that's there. Also, they are asking for a minor variance, but if you look at the allowed area, if it was ancillary building, they would be allowed to build only 10% of the lot area. They are using 15.73%, which is 57% over what's allowed. And according to the bylaws, the maximum lot coverage in that neighborhood is 35%. With all the buildings around, it would be 48%, which is 27% over the limit. Major thing is that when you look at the backyard, there is nothing left. There is an end of the building, there is patio, there is 3.6 meters of grass, and then this building. The other thing, any noise in a building, momentarily everyone sits on their patios in front of their homes, and any noise reflecting from the house goes into the greenery. This being reversed virtually, at the moment when you put a radio there, you talk there in the evening, the back building will reflect the noise exactly onto the building, into our bedrooms and so on. So there is nothing that would buffer the noise. So number one, I don't think that it's an ancillary building, because ancillary building would be shed, gazebo, pool building. This is outside seating and a washroom. Also, the agent mentioned that they very often build garden suites. Well, if it's a garden suite, then is this far from my property line?
Okay. I'm just going to mention, just watch the time as well.
Oh, well, I think I'm done.
Okay. Well, thank you very much.
Thank you.
I will give you an opportunity to respond. I want to ensure there are no other speakers. Is there another person here today to speak to this application? No. Okay.
Okay, thank you for the opportunity to respond. So I want to cover a couple of things that the neighbor was pointing out. Number one, you should have a picture of it. We were in communication with the forestry division. What that picture doesn't show, the tree coming into Jonathan's lot at 346 Cranbrookhe, there's a massive section that's been dead for probably 15 years, and the arborist department have said that they're going to come in, and you could see it right there, when there were still leaves, right? If you back up, it's the biggest component, and they're completely dead. They have been for probably more than 10 years, right? Number two, the bushes that are in between the property, until we're on site, It is yet to be determined if those need to be trimmed back or not, but they're minor bushes, right? Number three, the garage, when she talks about the space between the house, right now in the garage under the old shared driveway, which has now been agreed to be demolished, the old garage took up far more space, right? Number four, the most important thing, talking about the sound, if you look in that picture right there, there has been probably for the last 10 years with Jonathan's young children, a gigantic trampoline at the back where I've been there many times where there's 5, 10 kids in there bouncing around all day on a nice day, making more noise than there ever will be with people sitting in the back having dinner under a gazebo. So I think, to me, that point is irrelevant. And we are going to be doing, once it's all done, some softscaping, probably adding perhaps some emerald cedars or some other type of plantation in there once we're in and on site. So I think the percentage that we're talking about from 10% to 15% would mean you'd have to take about 90 square feet off of the actual deck structure, which is pretty much an area to put a dining room table and chairs. And with respect to this type of building, I did not tell her that we're building a garden suite. I told her that I have built garden suites. A garden suite is a different animal altogether. Under this type of structure, the setback is 0.3 meters, which we're in compliance with on all three sides. And what we've done to make it less grand and a little more open is, if you're looking at the property here, on the left side it will be walled, and on the back side it will be walled, and there will be a ceiling. On the front it's open, and on the right side, looking at the picture, it's open as well, so it's a post in the front. So we've tried to make it so that it's not this giant, structure in the backyard. And if we need, one of the things I've talked with Jonathan about, which we're happy to do, is build a custom lattice wall down the adjoining wall to 344, which will still give an element of privacy because the spaces between the lattice are much smaller, and it will look very, very nice. But we thought leaving it open would actually be more enhancing because it's a little less large. Did I miss anything, John? And the hedge that's there now, Jonathan and family have lived there not for 33 years now, but it's a hedge that would probably have to be trimmed at the back, but it's exactly that. It's a hedge. And one of the options, if that doesn't work, is we would be prepared to put a section of fencing in there if the hedge is indeed in the way. So we're not trying to take away any privacy. We're just trying to build a structure that's suitable to the family.
Okay, thank you.
Sorry, I'm just wanted to ask some questions for clarification. Sorry. So, okay, so this is a storage area, a washroom, and a deck.
Right, so if you put the picture back up there,
Yeah,
right?
but I just want to let me go through it slowly.
Of course.
Okay, so the deck portion is going to have a covered component.
Right, so if you look at the back where it's the angled lines, in the back kind of grade section, the left side is a little powder room, if you want to call it that. There'll be a door facing forward, and the right side, where your arrow is now, there'll be another door, and you enter there, and that is a storage area to put, bicycles, lawn furniture, etc.
Thank you. And the white area, that's not going to be covered.
No,
or is it?
It's going to be covered by a roof, right? So it'll be covered out to the front like a roof. So the entire area will be covered with a roof.
Okay, and then, so the entire deck will be covered.
Yes.
And then there will be two open parts.
Front wall and right wall, if you're facing the unit, are open.
Okay.
But we would be open to closing the right side if that makes it better, and we could close it with a lattice wall so it's still airy, but we thought it would be better open because it just makes it look not as large.
So, okay, so it's, so the deck is covered, the
Yes.
front wall and the right wall are open. Okay.
Correct.
Thank you.
Thank you.
Any other questions?
I have one question through you, Mr. Chair, to the applicant. On the plans, it looks, excuse me, it looks on the east elevation that there is wood screening. Am I just reading it wrong?
Where is that?
Drawing S303.
Yes. So okay, this has been a common misconception. So what you're looking at there, those are just the front, middle, and rear posts that you see. The screening is the opposite wall. So if this was this side over here and there's a wall over here, you can't draw the picture because your department wanted all elevations. You can't draw the elevation looking that way without seeing the wall that's over here. But on this side of the structure, there's only the 3 posts going up.
Thank you.
It does make it look, though, like it's a screen there now. Thank you.
Can I ask another question? I apologize.
I'm just going to stay here.
You might as well stay there.
I'll just stay here.
So just going back to the coverage variance, do you know the coverage variance, do you know if it applies to the white portion as well as the washroom and storage area, or does the coverage variance only apply to the washroom and storage area?
So the variance, as far as I know, the 15.7 whatever percent versus the 10 applies to the whole structure. I don't think it was isolated down into components, right? So the problem is, if you look at the front of the structure, to make it narrower or to make it shorter makes it virtually unusable. If you've ever seen someone build a deck, 10 feet wide, by the time you put a table, you can't pull a chair out.
No, that's fine. I just we're just trying to
Understood.
Trying to understand some of the components.
Yes.
I think there was a few things that don't seem as clear as we would like it to.
Anything I can answer?
Thanks very much.
Thank you.
Any other questions?
I guess I have a question.
Go for it.
I hate to ask this, and this is for either
I can't hear you. Sorry.
Well, why couldn't you have settled this without having to come with an argument between neighbors to the committee? Was this impossible to say? Was this impossible that it could not be agreed to without having to come to committee between neighbors? Go over, have a coffee, come to a deal, make something nice, everybody's happy. Why do we have to be here?
So may I address that? So number one, when we did the application, starting from the beginning, the clients met with the neighbor on the left side because of the shared driveway, and they had to go through the whole legal to set that up. We didn't know anyone else was coming today. We didn't anticipate it. I can tell you, in all the years of building deck structures, this is my first time we've had anyone opposing it. I can tell you that structurally and design and finish-wise, my company only does business by referrals. The quality is, there's no question about what's going to be back there. It's not going to be a big eyesore. But to answer the question directly, we never anticipated it being an issue. Right? We didn't know someone was coming today. We didn't even cross our minds that someone was coming today. That's the most honest answer I can give you.
Okay. Any other questions? Okay, thank you very much.
Thank you.
Okay, let's move into committee. I'll make one brief comment concerning observation. I do want to be mindful of hardscaping in the backyard, although I do acknowledge that there is no variance for soft yard landscaping at the rear. Although I would like to acknowledge that the property owner may have to address that at some point. So just be, perhaps just be cognizant. And I'm not sure if that's whether or not that concrete patio was included as part of the submission or not. Frankly, it's not a concern, but to address some of the concerns from the neighbor, it doesn't, granting these variants does not, essentially permit a hardscaping of the backyard. And I just want to make sure, because, we're dealing with lot coverage here. I just want to make sure that there is at least an awareness of maintaining some soft landscaping should that apply in this case. Those are my comments on this.
Just to clarify, Mr. Chair, are you saying there should be a condition of a minimum amount of soft landscaping?
No, I don't think there should be a condition. If the examiner is going to flag something, though, they didn't flag it, so it's not before us. But to assuage the neighbors' concerns, because, you know, a lot of times with these applications, they go ahead and get constructed, and then, you know, the landscaping comes in the 11th hour. Sometimes after the building permits are even closed. There are provisions in the bylaw that do speak to soft yard landscaping at the rear, and I think in that case, it provides some satisfaction to allow for a larger lot coverage. But the reason I speak to it is because it was brought up as a concern with the neighbor, and I also want to, you know, point out that, you know, a construction of a structure at the rear does not essentially, you know, there are still requirements at the rear to maintain a certain degree of soft landscaping. If there are, I should say, then those would apply. So I think the bylaw would have caught that if that was an issue.
I don't really have any major concerns with the application. I'm ready to make a motion.
Okay.
So I know, sorry, I did reread the staff report again, and I note that they did speak to portions being uncovered, and yeah, it's a long.
There are conditions I have noted from community planning as well as urban forestry. Standard conditions from forestry.
So I would like to approve subject to the condition of planning as well as urban forestry. And I note that the condition of planning will address my concern, making sure that it's a deck and not a building.
Do we have a seconder?
I second that.
Okay. Second by Mr. Mosiani. All in favor? Okay, the application is approved. Moving on to item 6, 90 Montressor Drive. The application is to construct a new dwelling. I have variances sought: rear deck projection, stair width, front yard landscaping, driveway width, and side exterior main wall height. I have submissions that include materials from the applicant, including drawings and an arborist report. Do we have the agent with us?
Afternoon, committee. Jonathan Benskowski, 301 Keewatin Avenue.
Good afternoon.
Good afternoon. How are you?
We are well. We are well today. We require perhaps a brief presentation on this.
Absolutely. If we could bring up the site plan. So what we'll see here is this is a lot that is somewhat on the crest of a street, which really leads to irregular kind of rear yards and side yard situations as it relates to the adjacent property. We also have approximately a 0.8 meter drop in elevation from the front to the rear. In terms of the built form of the dwelling itself, the only variance we have for that relates to the side main wall height, which in my opinion is for a modest 0.5 meters. In terms of the width of the driveway, we have tapered the driveway at the front. So as you see, as it addresses Montressor, it is actually below what would be the maximum in the zoning bylaw. That was done for two reasons. Mainly, it was done to preserve the boulevard tree as we see there as it curves around it. And in the arborist report that we did submit, it does identify that that tree will be maintained. Other than that, in my opinion, the variances are minor. It's a new build dwelling, again, with an only built form request that would relate to the side main wall height. Briefly, to just speak of the projection of the deck at the rear, as we see here again, as this is related on kind of the crest of the street, the dwellings to the north and the south both have a different spatial kind of use of their rear yard. So that elevated rear deck that is requesting a 0.5 meter increase really would have very little impact on the privacy of the functional area of where somebody would generally use their rear yard, which 99% of the time is the area most adjacent to the dwelling itself. It is a modest reduction in soft landscaping at the front, which again does relate to the width of the stairs, but in my opinion, it is minor and it really is appropriate for the development. I'd be happy to answer any questions that the committee might have if they have any.
Okay, thank you very much for the presentation. Do we have any questions of the agent or applicant?
I actually have a question from the applicant about the front yard landscaping. What is the reason that you're seeking this variance? Is this the driveway width that is more than the requirement or anything else?
Through you, Mr. Chair, Mr. Marziani, I would probably say it's more from the request of the width of the front stairs. But again, as the property would address the street, we do see there is a large boulevard between the sidewalk and the road itself. So if we were to go back to the site plan, in terms of the green area that would be there, yes, if we could zoom in at the front, there is a large boulevard between, again, the edge of the asphalt of the street and the sidewalk. And we've also, again, not increased that there. So in terms of what would address the street itself, you still will see a lot of green just based upon what that existing condition is of that large city boulevard that's there today.
And just to clarify, I see there is no urban forestry report on this, but you're maintaining the 3 trees that as shown on the site plan, right?
Through you, Mr. Chair, correct. There is not one tree, there is not one healthy tree that is proposed to be removed. There are 2 dead trees that are proposed to be removed, but they are not the ones that are on the city boulevard. So again, there is not one healthy tree being proposed for removal with this application.
Thank you.
I have a question. Regarding the width of the driveway, are there any example? I know, I think widths of driveways do really shape the character of a street. So if we have, let's say, several examples where there's wide driveways, that's part of the character. Are there examples of driveways that are this wide along the street?
Through you, Mr. Chair, along Montressor, yes. So this really is not a true 3-car garage driveway. The request is really, for the exact numbers, I believe it's for about 1.5 meters. But yes, along this portion of Montressor, there are double kind of 2.5 garages that do exist there today. But again, what I would go back to saying is we have tried to address and soften that by tapering it towards the street, as it not only fronts the sidewalk itself, but again, because we do have that large boulevard that is on the city property between the sidewalk and the curb cut. That again is below the zoning bylaw requirement. It's really the pinch point. I mean, I don't want to use the word pinch point. Maybe that was the wrong phrase to use there. But as we see, the width is only requested really for that portion that's adjacent to the front walkway. With landscaping, again, to the adjacent property next to it.
Sort of to Mr. Auspitz, his question concerning the driveway width. Is the intent to provide, I mean, I see access for 2 cars, but I'm just wondering why this veers from what we typically see as a 2-car garage, because it, you know, to your point, it does, to a certain extent, it does read as a 3-car garage. And I did have a similar question with respect to whether or not, you know, this number of, this opening for vehicular access is common on the street or not. I guess I'm curious with respect to the wider entry point. Is there a particular reason for that that additional width?
From what I understood from the owner, Mr. Chair, it was just to allow for some more interior storage in that garage while being able to park their 2 vehicles in there.
So in essence, it wouldn't really require the driveway. I mean, in essence, you know, like they could have provided some form of soft landscaping adjacent to the stair because it wouldn't restrict access to that garage. But I guess the reason that it's hardscaped is because visually you've got a larger door in that place, even though it is intended to serve one vehicle. Is it fair to say?
Correct, Mr. Chair. Essentially, you have a single door, essentially a single door size adjacent to a 1.5 size door.
Okay.
Yeah, if we were to go to the first floor or the basement, you would see it on there, where you would see you have a typical single garage door and then a 1.5 wide garage door.
Okay, thank you. Any other questions? Nope. Okay. Thank you. Let's move this into committee for discussion.
I can start. I do not like the driveway width. I don't think that that's appropriate. And I know the intent of limiting driveway width is in part to allow for a 2-car garage, not and keep an appropriate amount of landscaped open space, and also to create a less of a car-dominated streetscape. Adding that 1.5 meters, I don't think it meets the appropriateness test of the Planning Act. But the other variances in balance, I don't really have any concerns with.
I'm on the same page. I had the exact same comments with respect to the driveway. I mean, I understand sometimes we get applications where there's a need, you know, particularly, you know, a lot of cases access. Sometimes there's a tree in the way. They need to, you know, like the word that we used before, flare. They have to flare the driveway. But in this case, it's almost as if they could just as easily provide, they could, you know, provide access for a 2-car garage with the 6 meter and then still provide, increase or reduce the variance for soft landscaping and reduce it, you know, which would in turn reduce the variance being sought for the driveway width. I mean, I think the two variances they're kind of working hand in hand, right? The two variances that came up, you know, one addresses the other.
Fair enough. So maybe both are a little bit of an issue, but I do want to point out we had previously approved wider driveways in some instances, and I think this one is a different context than what we've previously looked at. In this particular instance, we don't see the same precedent of 3-car garages or wider driveways. So I think that this we have to take into consideration the context, and this context is different from what we've previously looked at. I'd like to put forward a motion to regarding the application, if that's okay, unless
if there's no other comments.
I just want to add one more thing. Sorry. I think with the stair configuration, I can see an opportunity for the applicant to increase the soft yard landscaping. I think it's a very generous and wide stair, and it's connected to the front, whereas we don't want to design the building, but I think it can be like reconfigured to create more soft yard landscaping. So that's my main concern with it.
It's almost as if you've got a driveway and you've got a stair, and you have both as opportunities where there's room, where there's wiggle room, and in turn that, as I stated, would address the additional variance of soft yard landscaping. So to your point, I agree, and perhaps I'll give a little bit of flexibility to the agent or the architect in you know, with their own design to be able to come into compliance with some of those standards.
I'm just wondering whether we could go back to the applicant and ask whether he has any suggestions of how he could lessen that impact, reduce the variance.
Well, yeah, I mean, I think you bring up a good point in that it could be addressed through one of two variances to address a third, so perhaps, yeah, that might be helpful. Okay, let's go back to the applicant. I'm going to pull us out of committee, and if we can just get the agent back on the line to speak to two comments that were brought forward by our committee members.
Okay, yeah, thank you, Mr. Chair. And you were all very correct. It really is an A's leading to B, which is leading to C, which is creating the sum really of A, B, and C all together. I think the option we could have is to entirely remove the request for the soft yard landscaping and comply with that fully. What that would invariably do would either force one of two things. One is reduce the width of the driveway or the width of the stairs. In terms of the driveway itself, there might be a little bit of room to add some additional soft landscaping adjacent to the stairway itself, with a little bit more of a buffer there, creating some area there. So we would be prepared to comply with the front soft yard landscaping, which would invariably reduce the magnitude of the other two variances going hand in hand.
Okay. Any questions? Okay, if there's no further questions, we'll move back into committee. Thank you very much.
Mr. Chair, can I just verify he's made a change to the application?
Yes, sorry.
Yes.
Sorry, I was going to.
I'll move out of committee for a moment.
Yes, I will formally be withdrawing variance number 3.
With respect to the soft yard landscaping, can we pull up the
Correct,
notice?
Mr. Chair.
Thank you. Okay, is that answers? Thank you. Okay, so we'll move back into committee. Mr. Aspitz, how do you feel about that?
I mean, I'm more concerned about variance 4 than I am about variance 3.
Yeah.
I think both are an issue. I'm not so much concerned about variance 2, provided variance 3 is met. So I'll put forward a motion. I'm ready to put forward something.
Yeah.
Just go.
I will, for the record, I do share, similar concerns in your observation with respect to the driveway width.
Yeah. So I see that there's no staff comments. So I would like to put forward a motion to approve variance 1, approve variance 2, refuse variance 3, refuse variance 4. Oh, sorry. Remove variance 3 because it was withdrawn. Refuse variance 4, and approve variance 5.
For the reasons stated.
Because the width of the driveway is not appropriate. Doesn't maintain the overall character of the street, and facilitates a non-pedestrian character, and facilitates an automobile dependent type of character.
Okay, thank you. Do I have a seconder for that?
I'll second it.
Mr. Schwartz seconds that motion. All in favor? Okay, I see we have one opposed.
I am opposed, yeah.
Okay. Mr. Marziuri?
I think we have 3 votes already.
We do. For the record,
Well, I think the driveway, since it's not the main thing that is creating variance number 3, that's not my main concern, so I'm just not supporting the motion.
Okay. So opposed, Mr. Mazuri. All others in favor. So the motion passes. Moving on. Item number 7, 203 Johnston Avenue. purpose of the application is to construct a new two-story dwelling with covered porch, rear walk-up, and rear deck. I have variances for lot coverage, number of stories, as well as a rear platform area. And on file, I have material from the applicant as well as a memorandum from Urban Forestry. I believe we have a second speaker as well. Just confirm that that as well. We'll do that in a moment. Do we have the agent?
Hi, yes, I'm here.
Hey, good afternoon. Given that we have another speaker, I believe we should hear a brief presentation on this. When you're ready, if you can just state your name and address as well, if you can give us a brief presentation on the application, we'd appreciate it.
Sure. Thank you, Mr. Chair and panel members for the opportunity to speak at the hearing meeting. My name is Ali Shams from Archdesign Architects. I am the architect and the applicant for this application. My address is 4325 5 Shepherd Avenue East, North York, Ontario, M210G4. So I have a very brief presentation for this application, given that you have spent a lot of time on the previous applications. This application, which is before you, is a straightforward application consisting of just 3 variances, which I believe are minor in nature and appropriate for the development of the land, and in general meets all 4 tests of the minor variance applications. We did not receive any objection letters from the neighbors, and we are only requesting relief from lot coverage, number of stories, and second floor platform. Apart from the lot coverage variance, which is precedented and within the approved percentage, other 2 variances are intertwined and related to the new amendment to the zoning bylaw, which passed last year and is in effect from November 2022. Specifically changes to the definition of the basement and first floor. As a result of these changes to the definitions of the basement and the first floor, as you know, the proposed house is now considered as a 3-story building, meaning that the floor which was previously considered as a basement is now considered the first floor, the first story is considered the second floor, and so forth. So the wood deck at the rear yard is considered a balcony at the second story and listed as a variance. The neighborhood predominantly consists of 40-foot lots, which is being developed with a more modern style of the architecture, and with the same concept as we have proposed to develop this land. The proposed building is in harmony with the neighboring properties in terms of the architectural style and concept. Other than these 2 variances, 3 variances, we are complying with all other zoning bylaw requirements, including the side yard setback, building length, and the building height. To conclude my presentation, I think this application is minor, meets all 4 tests, and deserves approval. Thank you for your attention, and now open to questions.
Thank you very much. Do we have any questions of the agent or applicant? None? Okay, we have another speaker. Good afternoon. If you can just state your name and address for us.
Winifred Young, 181 Johnston, and I'm representing myself and my husband, Stephen Wright.
Okay, thank you.
Should I continue?
Yes, please.
Yes, we object to the variance for the rear platform at the second story at 21 square meters versus the 4 square meters permitted. The deck design is excessive and introduces privacy issues for the neighbors, and it is not necessary for an owner-occupied home versus having one at a slightly above grade level. We were also concerned about the 3 stories that is structure that is not in character with the street. But I do note that the agent has made a comment earlier about the different stories. So that's basically what our main concerns are.
Okay, thank you. So I just have a clarifying question. If I understand correctly, your main concern is with respect to the area of the rear platform.
Yes, so that would be the variance number 3.
Okay, thank you very much. Do you have any questions?
The size is just excessive. The variance is in our minds it is a major what is being permitted.
Okay, thank you.
Thank you.
Through you, Mr. Chair, I'd just like to ask a question of clarification. Just looking at the location map, you're located 5 properties east of the subject property. Is that correct? Was it 181 Johnston?
Yes, 181, yes.
And you're concerned about privacy of your property?
Of the neighborhood.
Okay, thank you.
Any other questions?
I actually have a question from the applicant. I let him
Of course.
respond to.
Well, thank you, and I to your point, I almost forgot to allow the agent to respond. So can we get him back?
Yes, I'm here.
Perhaps Mr. Marzuri, you would like to.
Yes, in regard with variance number 3, the reason for this variance is because your first floor is considered second floor, and this rear deck is considered as a platform. Am I right? As opposed to
That's
a
right.
because
That's totally right.
It hasn't been reviewed as a deck. It has been reviewed as a platform.
No, because the first story, which would previously considered as first story, now is under the new amendment to the bylaw is considered as the second story. So the wood deck is considered as a balcony for the second story, not the wood deck, an elevated floor deck for the main floor. So, but this concept is widespread in the neighborhood, and if you take a look at the supporting material I have sent before, if it's possible, please open the supporting material. The second picture shows the character of neighborhood and how the rear decks are developed in this neighborhood. They are all elevated and they are all have access to the main floor.
Thank you.
Can I ask a question about that photo, please? So when I'm looking at the wood deck in that photo, just to confirm, is that the property that we're dealing with, the one with the wood deck, right to the
Neighboring.
But it's
yeah.
yeah. So
I believe it's the
They're neighbors. They're neighbors.
It's the neighbor.
So right at the right. So over the fence is a neighbor, but yours is the one with the wood deck. Is that correct?
That's right.
Or
that's right.
Okay.
The closer one, the closer one is our property, and the other ones are the old neighbors.
Okay.
You could see 205, 207, 209 all developed with the same concept.
Okay, okay, thank you very much. I just wanted to know where I was looking from. Thanks very much.
No problem.
Do we have any further questions? Okay, we'll move this into committee.
Everything appears to fit the context. And I want to also point out, I don't think, I know often we ask for privacy screens. I don't think that that's appropriate in this instance because the context, the precedence is, sorry, not the precedence, the context has already been set where privacy screens are not being provided. So the impact has already been created. So I would like to motion, actually, yeah, I'd like to let others speak before.
I am also ready for a motion.
Okay.
Yeah. I just also point out we have standard condition, recommended condition from urban forestry.
Yeah.
Mr. Martiri, or?
Yeah, I'd like to make a motion to approve with subject to urban forestry condition.
Do I have a seconder? Mr. Auspitz? Seconds that. All in favor? Okay, the motion passes. The application is approved. Item number 8, we dealt with earlier.
Thank you so much.
Thank you very much. Item number 8, we dealt with earlier for 521 Davisville Avenue. So we're moving on now to item number 9, 50 Dudley Avenue.
Hi, can you hear me?
Yes, we can hear you. Just give me a moment. So just pulling up the application. Okay. The purpose of the application is to construct a new dwelling with variances for east and west side yard setback, side, exterior main wall height, and lot coverage. On file, I have material from the applicant, staff report from community planning, memorandum from urban forestry, as well as a letter from 52 Dudley Avenue. Do we have the agent with us?
Yes, good afternoon. My name is Christine Dan on behalf of the owner 50 Dudley Avenue, and my address is 2710 14th Avenue.
Okay, thank you. The floor is yours. Are you prepared to provide a brief presentation on this application?
Yeah.
Okay. Whenever you're ready.
Before my presentation, I'm going to request a change to the variance number 3. The proposed height of the side exterior main walls facing a side lot line is reduced from 8.22 meters to 8 meters. What's before you today is to construct a new 2-story detached dwelling. There is total 4 variances related to side yard setbacks, side main walls height, and the lot coverage. The 1.5 meters west side yard setback and 1.55 meters east side yard setback we are asking is very consistent and characteristic in the area. The existing house has 0.49 meters setback at the west and 1.96 meter at the east. We actually refined the side yard setbacks. The generous 1.5 meters setback on each side will allow for light air circulation, safety, and privacy. Again, the side main walls height, we have reduced it from 8.22 meters to 8 meters to adjust city planning's concerns. The revised 8 meters main walls height is keeping with the intent of the zoning bylaw and neighborhood character. The 32.49% lot coverage we are asking is on the average of the granted lot coverage in the surrounding neighborhood. The bay window projection above the garage door technically counts as well because it sits on top of the architectural canopy. It's 0.49% of the area, and summed together to get you the total number of 32.49%, excluding the bay window projection. The footprint of the dwelling itself is actually 32%. Since city planning has no objection to our proposal, we believe our proposal is minor and meets the fall test. Thank you for considering, and I'm happy to answer any question you may have.
Okay, thank you very much. You have any questions? Okay, no questions. I believe we have another speaker. We have a speaker in person here. If you can come down to the podium, state your name and address for us.
Hey, good afternoon. My name is David Ho. I'm the neighbor of, I live in 48 Dudley, family of 4. I'm sorry I didn't send my comment in advance because it's the first time I attend this kind of meeting. First, I didn't have any comment at the beginning because I saw the owner, they kept most of the plantation and the trees, which I'm happy. But after I'm here listening to the other speakers, their presentation, what I'm worried and my concern is the backyard. There's a big tree which located on the on the southeast corner at the border, which is close to also the border of my backyard. And the house, after from the drawing, after they complete the construction, is only the corner that is only 8 feet away from the big tree, 8 feet 2 inches away from the big tree on the corner. And then there's also a deck built besides the big tree. What I want to bring the attention to the committee and the agent and the owner, that when they have doing the construction, make sure that the tree won't be damaged, because that tree is, the trunk is much bigger than this stand and is more than 50 feet high. So if any damage to the tree, it won't seem at the beginning, but at the end, whichever side it fall down is cost a lot. You see there's a big tree on when the house is done, it's just on the corner up there. Yeah, that's the big tree. The wooden deck besides the way, that's the tree. And it's just at 8 feet and 2 inches away from the house, right? And also, after they build the house, the deck is just beside the big tree. That's what I concern and worry about. Other than that, no more, nothing. And I'm sorry that I didn't send my comment in advance because I didn't know the procedure, and I thought looks good to me at the beginning. But when I hear, I'm happy to be here, attend the hearing and listen to other speakers' comment. Then I realized I should bring that up.
That's no problem at all, and we're very happy to have you here today to address us.
Thank you, sir.
Okay, thank you.
Welcome.
We have any questions? Okay, I believe we have another speaker from 52 Dudley Avenue. Is he online? Yes?
Hello.
Hello.
Hey, how's it going?
It's going well. How are you?
Not bad. So I'm Daniel Philippe, and I'm from 52 Dudley, adjacent neighbor on the other side. I'm speaking on behalf of myself, my wife, and my brother-in-law who reside at 52 Dudley Avenue. So my main concerns, if you look at the letter of objection in the supporting documents, just to start off with that, I was requesting a deferral due to the lack of, in regards to the urban forestry requirements, incomplete nature, pun intended, of where all the trees located on the site, 6 meters, they weren't all labeled. Not to mention, if you look along my property line, it's all trees with 50 Dudley. So I'm concerned in regards to the setbacks, like how the impact without an arborist report or anything like that, like how they can say that these variances being proposed won't have a negative impact on the natural landscape surrounding not just my border, but also the 48 Dudley. He expressed his concerns there as well. There's no arborist report that was done, and it's incomplete here. So I don't know if I can pass that petition, the panel, to defer this or deny this application until they have more like information in regards to that, because it's going to have a big impact.
Okay, thank you. So we have a request for deferral. I'm going to turn this back to the agent to speak to if there are no questions of the committee at this time. None? Okay, can we get the agent back?
Yeah. With regards to the concerns from the two adjacent neighbor, I apologize that we incautiously didn't highlight the tree beside the walkout on the plan. So, but this tree is shown on the site plan and the survey, and we do have included the photo of that tree in our submission. It's on the last second tree photo. It's between tree number 6 and 7. And we accept and acknowledge that we need to submit a complete application to permit remove all injury to the trees to urban forestry before the building permit stage. And we will work with them to preserve trees as much as we could.
Okay, thank you. Have any questions?
I actually have a question from the applicant. It appears to me that there is no communication with the urban forestry between for these trees. Is there any back and forth, or it's just you just receive this and you move forward with this hearing?
We haven't prepared our office report, but after we prepare it, we will communicate with urban forestry to preserve the trees.
Any other questions? Okay, to the agent, thank you very much. Let's move into committee.
Can I say something regarding trees? I understand that the forestry, they do consider all trees on properties that are going to be impacted by development, but they only will object to an application if impacts of trees are specifically as a result from the variance sought. When I'm looking at the relief being sought, there's relief to coverage, there's relief to interior side yard and building lot height, but I don't see how the specific variances could impact anything based on an as-of-right condition. But that being said, we do rely on forestry's comments, and they do have a condition. Their standard condition regarding trees. Specifically, it's condition 2, which states submission of a complete application for a permit to injure or remove privately owned trees as per City of Toronto's municipal code. So if the applicant were to injure a tree, there is a separate process to deal with that, but I don't think that's within the purview of this process, just because the variances themselves would not result in impacts of trees.
Even the side yard setback?
It's 30 centimeters, 1.8 meters, moving 30 centimeters, I don't see how that could. I'm not an expert or an arborist, but I don't see how 30 centimeters could result in an impact to trees.
I shared similar observations.
Okay.
Any other comment?
Nope.
We have a motion?
I could put forward a motion. I'd like to motion to approve as modified, which is reducing the the wall height from 8.22 meters to 8 meters, and also subject to condition number 2 of forestry.
We have a seconder? Okay, second by Ms. Casson. All in favor? Okay, the motion passes. The application is approved.
Thank you very much.
Okay, moving on. Item number 10, 331 Glengarry Avenue. The purpose of the application is to construct a 2-story side and rear addition, attached garage and rear walkout. It requires variances for lot coverage, east and west side yard setback, as well as east side yard eave projection. On file, I have material from the applicant, memorandum from Urban Forestry, staff report from, and a staff report from Community Planning. Do we have the agent with us, or actually the homeowners? With us?
Yes. Good afternoon.
Good afternoon. If you could state your name and address for us?
Yeah, Jamie Shirato, and my wife is with me as well, Lorraine Shirato at 331 Glengarry Avenue.
Okay, thank you. Would you guys like to hear a brief presentation on this?
I think there was some modifications to the application that were made.
Thank you for pointing that out. Can we go back to the homeowners and ask if there's any changes that they'd like to make to the public notice or to the variances noted on the public notice?
Yeah, there was a revised application that was submitted to the city planner based on some feedback that was received from the planner.
Okay.
So I believe should be on file.
And have any of the variances changed that were sent out on the public notice?
Yeah, these are the 2 variances now, the ones that you're showing right there.
So we did receive.
Mr. Chair, for our records and minute keeping, the owner would need to read out which variances are being changed and what is being changed numerically.
Thank you. Yes, if we can just pull up the public notice, I'll do my best to take you through this, but what I'd ask you to do is just go through each of the 4 variances and let us know which ones, I should say, are being changed and which ones are being asked for as applied.
Yeah, so the first variant, so the original application was for 40% coverage. That has been amended to lot coverage of 37.7%.
Okay.
As per feedback from the planner.
Yep.
And then the only other variance I believe that remains is the west elevation variance, which is the required setback being 0.9 meters, and our setback is 0.695 meters. I don't know which one of these, just looking at it. It is that, yeah, number 3.
I see that. So the proposed addition's west side yard setback is, what is the new number? Or that's maintaining at 0.69 meters?
0.695 meters, yes.
Okay, so we're not amending that, but we are removing variance number 2 and variance number 4, if I'm not mistaken.
That's right. And the staff report, I believe, that was submitted refers to the variances that are being requested.
Yes.
So you can see number 2 and number 4 have been eliminated and 1 and 3 have been modified.
Yes, I do see that. Okay. Okay. We need a brief presentation on this? No? I'm seeing heads. Okay. Well, I've looked at the other committee members. It doesn't appear we need a full presentation on this, unless there's something that you would like to add for us.
No, I had a brief statement prepared, but if it's not required, I can forego it. I know you have a lot more applications to get through.
We appreciate that. I do thank you for taking us through those variances that have been eliminated and modified. I think that answers actually some of the questions that we had. Okay, if there are no questions, we're prepared to move into committee.
Mr. Chair, I have no concerns with the application, and I'm prepared to make a motion unless there are other comments from the committee members.
I share in your observation.
No concern here.
Okay.
Okay.
Ready for a motion?
I am ready for a motion. I'm prepared.
Fantastic.
I would like to move a motion to approve the application subject to variance 1 being modified for the proposed lot coverage from 40% to 37.7%, to eliminate variance 2, to modify variance 3 for the proposed west side yard setback as measured under the zoning bylaw from 0.69 meters to 0.695 meters for the rear addition, and to eliminate variance 4, and subject to forestry conditions.
Okay. Do I have a seconder?
I second that.
Okay. Second by Mr. Marzuri. All in favor? Okay, the application is approved.
Thank you.
Item number 10, 331 Glengarry Avenue. The purpose of the application is to construct a 2-story side and rear addition.
Mr. Chair, was there a conflict declared for this?
We have a conflict on this one?
10? No. It's Carmichael, 11.
Believe it's number.
Yeah, I'm number 11. I'm 61 Carmichael, and I believe there was a conflict declared.
We did 10, right?
I'm sorry, guys. It's yes, it's been a long morning. I apologize. We yes, thank you for the clarification, Ms. Casson. We are on item number 11.
Yeah, I was prepared to come here and bid you good morning, but I'm bidding you good afternoon. I am Jim Pfeffer from 95 St. Clair Avenue West.
Okay, thank you. Just give me one moment. I'm just going to read off the purpose of the application for us and some of the materials, the materials submitted. So the purpose of this application is for an air conditioning unit to be located on the side of a dwelling alongside a lot line. Variances are included. The variance, I should say, is noted in the purpose of the application. And on file, I have material from the applicant, in addition to a letter of objection and site photos from number 63 Carmichael Avenue. And we have the agent with us in person today.
I am indeed here from 95 St. Clair Avenue West. I'm Jim Pfeffer. So as you noted, this is about bringing an air conditioning unit that has already been installed in compliance. And this is a little bit unusual because there's no zoning review, and this will not be subject to a building permit because these air conditioning units were already shown on building permit drawings. They were viewed by a Toronto Buildings inspector, and that inspector signed off on the building permit. It's been closed, so there won't be a building permit application following this process. And if you bring up the booklet of material I sent in, I'd really appreciate it. And I think the minor nature of the variance that we're seeking today is basically, you can see it in the variance that's before the committee. You can, as of right, put an air conditioner mounted on the wall, and that air conditioner can be up to 30 centimeters from the property line. So our air conditioner is on the ground, and it's 15 centimeters from the property line. So we're talking about a difference of 6 inches in the distance from the property line that this air conditioner can be. So it's really a very minor case. As I mentioned, the homeowners did everything right in terms of the fact that it was shown on a building permit drawing. Their architect and contractor never called their attention to the fact that this was not supposed to be here. And then the building permit got signed off on. However, when the neighbor raised an issue about concern about the noise from this air conditioning unit to the contractor, the neighbor and the contractor talked, and it was agreed upon between the two of them that a good solution to this problem would be to construct a sound mitigating enclosure around the air conditioning unit. The contractor took that idea to the homeowners who, not feeling compelled to do so by the bylaw, but just out of neighborliness and at considerable expense, $8,000 they spent building what you can see here, a really beautiful, well-constructed, sound mitigating enclosure around those air conditioning units. So the owner, in good faith, took an action that was agreed to by the neighboring homeowner, and that neighboring homeowner was in contact with the contractor as he was building that unit and was encouraging of that sort of effort. So it was only after it was all completed that a call was made to a bylaw officer about this violation. And that complaint from the bylaw officer came after the closure of the building permit. Going on to the next page, what you'll see is the building permit site plan. That stamped by Toronto Buildings. It doesn't show AC units in the side yard. What it does show is pool equipment, which includes a heater and a pump, noisy elements in the side yard. On the next page, though, you can see signed off on by Toronto Buildings is the AC application, which shows the 2 AC units in the side yard. Further in this thing, you can see the AC units there. They're spec'd on the plan. These are the quietest AC units in the entire Carrier lineup. They're very energy efficient, and they're the quietest units that Carrier makes. On the next page, you can see it was signed off on by Toronto Buildings before the complaint was made by the bylaw officer. On the next page, I've given you the narrative of what's happened in terms of back and forth between the contractors, the owner, and the neighbor. Both of the contractors involved submitted a statement that you have in front of you, basically saying that the neighbors were aware and supportive of this effort, and it was made in good faith through the entire part of the process. And then just towards the end, you can see the cost of this, over $8,000, made in good faith. The other thing I'd like to point out to the committee is that, so we're talking about 6 inches. If we can't have this here, the remedy is to, at considerable expense, lift it up off the ground and push it against the side of the house. That would be compliant. That would be at the detriment, to my mind, of both the longevity and the performance of the AC unit. It may, in fact, be noisier that way. It could be put in the front yard. It would be unsightly, just as noisy. There's no good solution there. It could be in the backyard, which would be noisier to both the applicant and the neighbors. And it would also, just be costly. It would take up rear yard amenity space, and it would continue to be unsightly. There's no remedy here except letting this thing be, which is very, very close to what the bylaw in fact allows. And there's been very good faith efforts at considerable expense made, in conjunction with the neighbors to kind of address this issue. So I'm really hoping that the committee will be understanding here and allow this extremely minor variance. Thank you.
Okay, thank you very much. Do we have any questions? No questions?
Sorry. How are you going to maintain that at basically right at the property line?
Well,
because the sound enclosure is at the property line, right? Because wouldn't there be a
if you take a look, so the photo on the right, and you'll be aware that it is the most common condition throughout the whole city of Toronto to have your air conditioner on the property line. I mean, you'll have seen that any number of times. You can see here, they can get to the air conditioner from the back. They can get to it from the other side. And the air conditioner itself is about 3 feet wide. They have a 4-foot side yard setback, so 1.2 meters. This is a brand new house. The prior house was about 0.56 meters from the side lot line. So, getting access to that, it's not difficult. And that's also just not, people always make these things work, and it can certainly be made to work in this condition.
Any other questions?
I have a question actually. So does the immediate neighbor to the right has a gate to the backyard on this side?
So the immediate neighbor to the right, so their property is 0.46 or 0.47 meters, so about 18 inches from the property line. And the prior house on this lot, the subject lot, was 0.56 meters. So in the past, there was a pretty narrow space between these houses, and that space is actually, and the accessibility between the two units has actually only been increased by the construction of this new house. The neighbor, I believe there is a gate that was constructed by these homeowners. My clients constructed a gate from this side yard into that neighbor's rear yard, I believe. So there is a gate there, but those neighbors only have 18 inches basically between their house and the property line. So they never really had an access on their property along that side of the house to the rear yard.
Thank you.
Just to confirm as well, there's no right-of-way.
There is no right-of-way, there's no easement,
easement.
nothing of the kind.
Okay.
Nothing of the kind. This was never a mutual.
So essentially service.
The ability to access the side yard for service has absolutely been increased by the construction of this new house. And my clients, I dealt with a neighbor on the other side, and the neighbor on the other side had requested that our clients, create mutual landscaping between the two properties, keep it open for mutual access, and actually put the gate beyond the neighboring house so that neighbor could use the space between the two houses, including the walkway on my client's property, to access the rear yard on the other side. And, without a hesitation, our clients did that. They put the gate beyond the neighbor's house, and the neighbor on the other side actually walks over my client's property to get to their rear yard, and they were only too happy to do that.
Okay. No other questions? Okay, thank you very much. We have the neighbor here as well. If you can come down and state your name and address for us. Good afternoon.
Good afternoon. My name is Nancy Chaplock. I'm speaking on behalf of the owners of number 63 next door, Elisa Chaplock and Elliot Tepperman. We object to this variation for a number of reasons. As a preliminary matter, please note that the documents referred to by the applicants were not submitted by the required November 30th deadline. That's a deadline that was in the notice of hearing. It's a deadline, I understand, that's in your committee of adjustment rules. They were not submitted until December 5th, giving us virtually no time to study them carefully, to consult. They were filled with technical documents, and we've been prejudiced by that breach of your own timing rules. So query whether those documents should even be considered, and if they are considered, please consider whether the weight given to them should be limited as a result of our prejudice. We have a number of reasons why we object to the variance. None of our reasons relate to noise, although the applicant's submission spent a lot of time talking about noise issues. Those are not what we're concerned about, and they're completely irrelevant. The applicant spent much of their discussion and their materials talking about this screen that was built to help with the sound barrier. And they're implying somehow that the owners of 63 condoned or consented to those non-compliant units by talking to them about the screen. That is misleading. Any discussions about the noise screen and the construction of the noise screen took place under the understanding that those units were in compliance. In fact, the owner told the owner of number 63 that she checked with her architect and her builder, and they both said the bylaws were in, the units were in compliance. So we proceeded talking about a noise screen, which, by the way, we did not see any plans, we did not participate in the completion of it. We proceeded on the assumption the bylaws, the units were in compliance. Nothing we have done in any way has condoned or consented to non-compliance. We found out after the fact from the city that the units were non-compliant, and since that time, we unequivocally stated that they must be brought into compliance. Discussions were had with the contractor about relocating the units, and it seemed for a time this was going to be done. However, much delay, they chose to apply for this variance instead. We submit the bylaw provision they seek to vary has no application to this situation. It is a rule which permits a limited side yard encroachment for a wall-mounted unit. These are not wall-mounted units. They are ground-mounted units. The applicants are trying to ask you, the committee, to turn a rule specifically for wall-mounted units into a rule for ground-mounted units, where entirely different considerations apply, including access and safety. To add insult to injury, they go even further and ask for their 2 ground units to encroach even more than would be permitted for wall-mounted units. This certainly cannot be considered a minor variation. Turning to the serious adverse impacts on number 63, I refer you to the pictures that we submitted. The first picture you will see is the gray unit. Our wall is on the right side. The second picture shows the black screened unit. Our backyard is on the right side. I take serious exception with the comment that was made that we do not use that lane between from front to back, because we definitely do. That is an access to our backyard, and it's the closest access to our deck. Please look at picture 3. It shows a small woman walking toward the backyard. She's trying her best to navigate, but with difficulty given the very small space between the gray unit and our house. Please refer to picture 7, little ways down. Is that 7? That's the view from our deck of that black unit that they installed. 7 should be a picture of a man in an orange jacket. Could you scroll a little further? There he is. Okay.
I just ask you to wrap up.
Pardon?
I just ask you to wrap up.
Okay. He is unable to fit between the gray unit and our house. The black unit encroaches even more. not only is our access impeded in the event of a fire or medical emergency, access for firefighters and paramedics and their equipment is seriously compromised. They might not be able to get through at all, given the very tight space. These units should not have been installed in their present location. They can be removed and replaced with wall-mounted units or front or rear units that comply with the bylaw.
Okay, thank you very much. Do we have any questions of the speaker?
Sorry. Yeah, I'm understanding you mentioned several concerns, but in terms of practicality, your primary concern is access to your backyard, correct?
And access to the backyard and safety of emergency people having to come in. Yes, I haven't talked about the aesthetics, but there's a very big black wall just up against our deck, which I don't have time to talk about. But yes, the access is close to non-existent, and it's a serious danger for, as I say, medical or fire personnel.
Thank you very much. That's it.
I have one question for you. Is there an alternative location that would be more suitable for these units?
We have said all along that we just want them in compliance. They can be moved up, and we don't care about the noise. Compliance is what we want. And as the architect said, they can be moved up onto or compliant units, can be placed wall-mounted, consistent with the specific bylaw that is before you. They can be ground-mounted, as they said, in the front or in the rear. They don't think that looks very pretty. Well, that's not an issue that we're concerned about. We're concerned about the access that their non-compliance has ruined for our property. It's not very pretty for us either, looking into their units up against the deck. We're very concerned about the diminution in the value of our property because of non-complying, the placement of these units and the limited access that we have now find ourselves.
Okay, thank you very much. Any other questions?
I have a question. What is the access on the other side of the property of your?
There is access. On
And
the other side
what
to
is the
get-
width of that access?
I'm sorry, I don't know.
Is there a walkway?
I think where are you? There's a very small one. A small walkway.
Thank you.
Okay. If there's no other questions, I'd like to give the agent a chance to respond.
Yeah, so right now, up on the screen, you do have the survey. So the house 93, the neighbor who is here in opposition, is there on the left-hand side. And there's that big black line, that's the property line between the two properties. And that house is 46 centimeters in the back and 47 centimeters in the front from the property line. There could be a fence on that property line, there could be anything. But that neighbor having as of right access on their property to the backyard it's something they never had as long as this house has been in place. It's just, they never had it. This house, the new house, replaces an older house that was 56 centimeters from the property line. And, these neighbors, for maintenance and access, are welcome to sort of go through this side yard. There is a gate into their backyard from this now wider side yard. So access is, in fact, improved. As an architect, I really take exception to the idea that we have somehow done something that is unsafe, that harms the access that's required by safety. That would be a building code issue, and believe me, there are no health and safety issues to this installation at all. And to imply otherwise is frankly, kind of irresponsible. These units could be, these very units that you see, at considerable expense, could be wall mounted. Someone could mount steel brackets to the wall, lift these units 6 inches off the ground. Access wouldn't be improved. To my mind, it may affect the longevity of the units, and it may affect the performance of the units. But when she says, well, there's a difference between wall-mounted and ground-mounted units, that's a difference between the installation method, but it has, it doesn't change the units themselves or the dimensions of the units, the sound of the units. And in terms of sound, I spent some time addressing to it because you'll see the contractor submitted an affidavit or a testimony to this committee that, as a matter of fact, when they built this thing, they did it both in cooperation and with the encouragement of the neighbor, and they did so because the neighbor had come to them with concerns about sound. Our material, I regret that it came up on the website late. I did send it to the application technician on the Wednesday before the hearing, so a day before the time frame. I didn't get a return response, and so it wound up, and I sent it again on the weekend. It didn't get up till later because I kind of pestered, but I had in fact sent it in. And there's nothing you see in my material that affects the substance of what you're considering here today.
Okay, thank you very much. Do you have any questions? Okay, no other questions. Let's move this into committee for discussion and hopefully a motion.
I have a few comments. Like, I don't have a decision yet, but I think there's a few things that need to be considered.
Yep.
Firstly, would you approve this application as, you have to consider the application from had it not been there? And I'm thinking if I was considering the proposal for a new air conditioning unit, I wouldn't want it to be 0 meter setback from an interior side yards. The second point is building permit was issued and this wasn't caught. So, and I'm not saying that an error in a building permit means that de facto it's appropriate, but it does suggest, but it does lead to, from a building inspector's perspective, it seems like it was so insignificant that it was completely missed. So those are the two things. And regarding why I wouldn't typically consider these appropriate as of right is things like maintenance. So the reason why you have a 30 centimeter setback from an interior side yard is because you do maintain these units. You have to wash them down. You have to take them apart every season. An HVAC person has to come in basically every season to maintain them. And that means that there's trespass onto adjacent properties if it's right at the property line. So those.
I acknowledge, I appreciate the fact that these units were not placed in the front yard. It may be there as of right, maybe the solution, but I think, the effect of, I think it's evident that the applicant is trying to come up with the best possible solution that, put it this way, the consideration takes into account, I think, the context, in this case, the neighbors, right? So would placing this in the front yard have less of an impact? I'm not I'm not sure. Specifically on the matter of access, I would agree with the applicant that they're not required to provide access. There's no right of way. If they wanted to put a fence, you know, or whatever, however they want, whatever they wanted to put there, they, you know, within you know, the framework of the city's bylaws, you know, it's their as of right. I mean, I'm a little curious, as you know, with respect to the variance, is specific to a wall-mounted air conditioner. I would agree with the neighbor that it's not a wall-mounted air conditioner. So even if we were to approve the variance, I don't know. I mean, it's really up to you know, Toronto Building to, you know, interpret whether or not that. But I think, you know, let's deal with the variance before us. And if it turns out that they have to mount the unit, then they have to mount the unit. But I don't think the impact is unreasonable overall. I don't think it presents a safety issue to either of the property owners with respect to access.
I would agree. I would agree with you on the access issue. I think that probably the most used access is on the other side of the property. So it doesn't, with the gravel treatment that was put down beside this property, the one next door, it would not appear that they were proposing to use that for wheeling things down it. You know, it doesn't, I think that there's adequate room, and it's a very common situation in the city to have such a close setback to a property.
So part of the access issue is, you know, if they have a desire for access, part of the issue is the fact that they don't have very much of a setback off their own property line to begin with. So, you know, why should that be put on the next neighbor to ensure, you know, I'm just not convinced. I think in terms of service, more than enough space. I don't see it as a primary, you know, it's not a walkway to a front door. There's no right of way, so I would agree with your observations.
The AC unit itself is from the applicant was actually mentioned to be 6 inches or 15 centimeters as opposed to 30 centimeters. It's so I agree with access. There's no right of access over an adjacent property. The AC unit itself was 6 inches as opposed to 0 setback. It's the noise mitigation that brought it right up to the property line. I mean, 6 inches is probably not ideal, but it's still probably enough to maintain it from your own property. So,
I don't see any issue with maintenance, and I mean, I think there's issues all the time that this comes up with where neighbors build on the property line. You know, they can try to make nice with their neighbor to get access when they need, if they need. We don't know that. And if the neighbor doesn't provide access, they have a right to go and get an encroachment, not an encroachment, they have a right to go and ask for a temporary access. And the city has its own course of action for neighbors to be able to rightfully access their property for maintenance and construction. There's another avenue for that. So I'm not, it doesn't kind of present as a major concern for me with respect to maintenance and access. I think there's sufficient access there. We ready for a motion?
Mr. Chair, I'm prepared to move a motion to approve this application. I think that it is minor, and I don't think that wall mounting it on, you know, with a slightly greater setback is going to make a big difference to the impact. So I think that given that it is minor, I believe the impact's minor, and I think it's within the intent of the zoning bylaw, if it's applicable. But I'll take that out of the comment.
Do I have a seconder? Okay, second by Mr. Auspitz. All in favor? Okay, the motion is approved. Can we get Mr. Schwartz back? I'm just going to check in on time here. I realize we are running very late today, and I am going to try very hard to get us back on schedule. Is anybody require a break at this time? Do we have a 5-minute break, or should we keep moving along? I'm trying to get us to lunch. Yeah? Okay. Let's keep going. Can we get Mr. Schwartz back? Maybe he went for lunch. Maybe we'll try to. Can't find him. Okay, I think we need to move on to the next item in the interest of time. If Mr. Schwartz does come back, if we can have him hold off until the item is finished with, that would be great.
So, Mr. Chair, through you, just be mindful that now you have 4 members.
Yes, I will take a step back to ensure that there's no tie on the next item. Okay. So moving on, item number 12, 37 LYONSGATE Drive. Purpose of the application is to construct a new 2-story dwelling with a covered front porch and covered rear deck. In terms of variances, front yard setback, lot coverage, building length, and building depth. I have materials from the applicant on file, as well as a staff report from community planning, as well as letters of support from 30, 32, 33, 35 LYONSGATE, as well as in that community planning report, some recommendations. Do we have the agent with us today? Do we have him online?
Yes, good afternoon. I'm Drew Laszlo, agent for the owner. My address is 193 Rowe Avenue, Toronto.
Okay. Require a brief presentation on this? No. Just give us a moment.
Through you, Mr. Chair, could we just check if there's anybody, I know we have the letters of support, are there any people registered to speak in opposition?
Yeah, similar question.
Through you, Mr. Chair, there is no one else registered to speak in objection for this item.
Okay, thank you for the clarification. I'm just going to check in with Mr. Auspitz. Would you like to hear a presentation? No, I see heads shaking. So I'm going to go back to the agent with that in mind and ask if there's anything you'd like to add. Otherwise, we will move this into committee.
No, I'm okay as long as the committee doesn't have any questions. Thank you.
Okay, thank you. Mr. Schwartz, just for the record, we did jump over to move on to item number 12. So I'm just going to ask if you can recuse yourself on this one, just because we started the item. Is that okay? I apologize. We're trying to get you through to lunch. He's walking out.
Mr. Chair, he doesn't have to leave. He just can't vote.
Okay. Listen in. Leave the room. Yeah, I apologize. Okay.
I think everyone is in support of this. I think could I make a motion to approve at this point with the staff recommendation? Or we need to discuss?
You can.
Okay, I'd like to motion to approve subject to planning staff's recommendation regarding developing in accordance with the east and west elevation.
Do I have a seconder?
I second that.
Okay, second by Mr. Marciuri. All in favor? The application is approved.
Thank you very much.
Okay. Moving to item number 13, 528 Castlefield Avenue. Just give me a moment here. Purpose of the application is to construct a new detached single-family dwelling with variances for main entrance height, front porch encroachment, canopy encroachment, side yard setback, building length, building height, side exterior main wall height, rear platform size, front yard landscaping, and FSI. In terms of submissions, I have on file materials from the applicant, 2 urban forestry memorandums, staff report from community planning, as well as a letter of support from 523 St. Clements Avenue and 529 Castlefield Avenue. Do we have the agent with us?
Yes, good afternoon, Mr. Chair. Arjang Behesh from Homeland at 49 Wycliffe Crescent.
Okay, just give us a moment. I do see some recommended conditions from community planning as well as urban forestry. Have you seen those?
Yes, Mr. Chair.
Yep.
Yes, we're totally fine with the recommendations of planning to build the building in coordination with the sidewalls. And we have seen the letter from forestry recommending deferral of our application, but we'd like to move forward with the minor variance application because we believe that we can delve into the matters of the if I can speak to the matters of forestry specifically right now, if you wish, Mr. Chair.
Yes, actually,
Sure.
that was my next question for you.
Definitely.
So thank you for
sure.
for bringing that up. If you can address, they did have some comments I'd ask you to speak to.
Certainly. If I could see slide number 4 of my presentation package on the screen, please. The tree in question that urban forestry has concern about is the tree at the very front of the property, which you can see if you zoom into the front. And now, at the very front, there is a driveway and steps, which makes the configuration of this house. And you can see that the driveway, which is usually the obstacle that most likely requires a removal of a tree, is situated on the other side, furthest away from that tree in question. So the only thing left are the walkway steps which affect that tree. So in our opinion, there are 3 possibilities. Either urban forestry requires the removal of that tree, or if they don't agree to the removal, they would allow us to injure the tree based on the current foundation and steps that exist. Or in the worst case scenario, Chair, if they require us to even not injure that tree, there are still procedures that we can have, for example, by having pyloned a concrete foundation or absolutely no foundation for those landscaping steps, which we can turn into landscaping steps. But regardless, this is a fight that we'd like to have a discussion with urban forestry. And as they have suggested themselves, we are totally okay with their conditions for us to go and speak to them after this hearing today to resolve the matter of that front tree.
So if we can just pull up the staff report from urban forestry, they are requesting deferral so that they can deal with this matter.
Yes, I know.
Is that something that you would consider?
As per normal, the application to urban forestry, we would like to have after the committee. It's a very normal process. Our arborist who has made the arborist report for this application had actually suggested for us to wait after the committee to deal with urban forestry because it's a normal process in North York for that to occur.
Well, unfortunately, we have to consider trees in our decisions, right? They do form part of the OP, and the trees inform our decisions at the Committee of Adjustments. So I'm sort of reluctant just to sort of pass the buck off to, urban forestry. And, they also take into consideration our decisions to review trees. So,
When we consider this time that none of the variances directly impact that tree, there is no direct variance for a front yard setback. The building is in fact pushed further from the front yard setback, and specifically in that portion where the porch is, it's pushed even further back to align with the neighboring property on the other side.
Well,
So-
it is ultimately your choice to make. You are the agent of the applicant.
Yeah, Mr. Chair, I believe that suggestion by Urban Forestry to defer the application that's their primary suggestion, after which they have written that despite this, if the committee moves forward, they would require as normal conditions for forestry. So even if we are accepted for the variances that exist, we would still have to deal with this tree, whatever the Urban Forestry decides, whether they decide to allow, they require us to remove it or injure it, that's up to them. And I think that they have suggested a deferral for our benefit in case, which I know is not going to happen, in case they require some sort of drastic change which would require us to come back to the committee for an additional variance. They have, I think, given that for our benefit to not come to the committee an additional time for an additional variance.
Okay, fair enough. I'm just going to look to my left and right here and ask, probably want to hear a brief presentation on this, or?
I don't need to. I think the main concern is the tree, which is clear to me.
So, do you have any questions? I don't want to prevent you from being able to have your time for a formal presentation, but I think it's just trying to in the interest of kind of honing in on the kind of concerns that were brought forth. I'm just asking specifically if there's any questions or concerns related specifically to forestry.
My point, Mr. Chair, if I may, is that there is nothing that would allow us to deal with this tree as long as there's a condition tied to the approval, for urban forestry condition. That's, I think, the main point.
I want to see a presentation because I have other concerns with the application other than just forestry. I have concerns with height.
Okay, very good.
But
So,
Mr. Chair.
Yes.
If the committee decides to defer on the basis of the urban forestry's recommendation, we don't have to hear them, right? We can just defer it prior to the hearing.
Yes, but I have
We need a
asked.
motion.
I have asked the applicant if he would like to defer, and my understanding is he'd like to proceed today with a review and
Okay, I agree.
Mr. Chair, just to clarify, the decision to defer is ultimately left to the panel. You may canvass the applicant for his or her opinion, but the decision to defer is ultimately in your hands.
Okay.
So just as a point of clarification, just to my point, it would be open for the panel to make a motion to defer prior to hearing the applicant, would it?
Correct, as long as you've allowed the applicant to respond to your deferral request.
I see. So we don't really have to hear his comments on the merits. We could make a motion for a deferral. It could be approved or refused. If it's approved, before it's approved, he gets to speak, and if it's approved, he no longer will be able to speak on the merits because it will be a deferred.
Correct. There's nothing that prevents you from passing or putting forward a motion to defer now after you've allowed the applicant to speak, unless you believe that evidence presented will help you make your ultimate decision.
I see. So we don't have to go forward. So if people think we should defer, we can just defer now. All right. I'm prepared to defer to everybody else, but I'm also prepared to bring a motion to defer if there's an indication of support for that rather than hear him.
Before you move that motion, do you want to ask the applicant one more time?
I'm not bringing the motion, I'm just,
I'm gonna turn it back to the applicant because it seems, and I'm trying to. It seems to me that there's a bit of concern with respect to the proximity of this tree in relation to the front steps, and we're just sort of reluctant to pass it over to forestry because we're really supposed to be reviewing the application in its entirety, including but not limited to trees.
May I speak, Mr. Chair?
Yes, of course.
Good afternoon. My name is Hamid Basht from Homeland at 49 Wycliffe Crescent. I am the co-designer of the house.
Okay.
I would like to save everybody's time and predict what will happen if we defer the application. The forestry department is either going to ask us to flip the design or push the building towards the back in order to save this tree. Well, flipping the design, obviously everybody knows that it's not a solution because then the driveway will cover the tree. So at the end, there's no other choice rather than pushing the building towards the backyard. And this idea, which is going to happen 100% if you go to forestry, is going to intrigue another minor variance, which is going to be the building depth. And that's something which both neighbors are not going to be happy with, and then we have to come back to the Committee of Adjustment with another variance. So we will come then to the very same point that we are right now. So it is to the benefit of everybody, and including the project, that we hear the project right now and deal with the forestry afterwards, and we will be completely all right with their condition that if it's approved, then we will we will apply for whatever the forestry is required.
Okay. Okay.
Thank you.
so, Mr. Chair?
Yes, you had a.
I think what I'm going to do is just in fairness to the panel, I'll make a motion for deferral and see where it goes from there, because we have been asked by forestry to defer. I have deference to forestry. They may be able to come up with a solution that is acceptable to them and therefore better result. So in having regard to the panel, I'd rather just bring the motion to defer, see where that goes. If we defer it, we defer it. Otherwise, if we hear it, we hear it. But I'm going to bring the motion to
Fair enough.
defer.
All right, let's hear it.
Thank you. Given the comments by forestry and their recommendation that this matter be deferred, my motion is that we defer this subject to reconsideration at another time and further input from forestry with the applicant.
Okay. Do we have a seconder? Okay, the motion fails. We've got our answer on that.
Okay, well, I'm fine with that.
I'm prepared. If the applicant wants to move forward, I'm prepared to hear the application.
Okay.
Staff have put a lot of work into getting us here today, as well as the applicant who's come here today. So let's hear it.
Okay, thank you very much, Mr. Chair.
The floor is yours.
Thank you very much. There are a total of 10 minor variances in our application today, and the topography of the existing property has triggered 7 of these variances. Now, usually, based on the average topography of applications we've had before, the finished grade at the front of the building, which defines the established grade, is around 1 foot above where the level of the street is. So, in the vast majority of cases, there is a positive slope from the street to the front of the house. In this case, the grade at only the front, not including the sides or the rear, has a negative slope, which is 1 foot lower than the street level, while we are required to have a driveway with a minimum positive slope of a minimum of 2% from the street to the front of the home. So the finished grade compared to an average project is 2 feet lower than normal. Now, this grade difference has also helped to trigger the new 3-story rule of the bylaw, which considers the basement of the home as the first floor, the first floor of the home as the second floor, and the second floor as a 3rd story, which doesn't even exist in this case. As a result, this difference in grade and the new bylaw definition have triggered variances number 1, 2, 3, 6, 7, 8, and 10. Without this grade difference, 6 of these variances would not exist, and 1 would be much less in terms of its variance figure. For example, variance number 1 mentions a slightly higher front porch, highlighted there in yellow at the very bottom. If you take a look at that slide on the screen, the established grade is calculated from the highest point of the red line at the front of the house, which is the existing grade, while our driveway has a positive slope. The real grade, including where our steps to the front porch begin and where the new finished grade of that area will be, is the portion highlighted in green, which makes this variance unimpactful. Variance number 2 exists because it has considered that same porch, which is even lower than where our first floor is, as a second floor platform, which it is not. Variance number 3 sees the front canopy above the porch, again highlighted in yellow at the front, which would otherwise be conforming, as non-conforming because it covers a non-conforming porch, because the porch is deemed to be on the second story, which it is not. Variance number 8 speaks to a second floor balcony which exceeds the maximum area limitation, while that variance references a rear yard deck highlighted in yellow on the same slide at the rear of the property, which is located on our first floor. It is not a second floor balcony. If I could please see slide number 2, I will speak to one of the points that were raised by the committee panel, the height. In terms of increase in building height, again, this difference in grade is highlighted in green at the bottom of the house. It has largely contributed to this variance in height. By calculating the building height from the bottom of that green portion, while in reality the entire driveway, the steps to the porch, and the grades surrounding that space will be filled to the top of that dark green line. Now, despite this fact, the entire increase in building height, which you see at the yellow at the very top of the house, is still minor, especially when considering that the front wall is lowered and the entire increase is at the sloped portion of the roof, which slants further back. It can virtually not be seen in perspective from eye level and from the streetscape. And if I can please see slide number 4, I'll speak to the extra building length, which is consistent with the massing of developments in the area, but specifically with our adjacent neighbors to the left and right. As you can see from the site plan, despite the 2 most immediate neighbors highlighted in blue being 70-plus-year-old story homes, and 2-story homes rather, their lengths are still consistent with the length and position both from the front and the rear of our proposal. The protrusion of their rear yard wooden decks are also consistent with the neighbors of our proposal. Thank you very much, Chair. That's my presentation, but I'm sure there will be questions which I will expand on further.
Thank you very much. I appreciate that. Do we have any questions at this time for the agent?
I have concerns with building height. I hear what you're saying, that the grade goes down towards the rear.
Yes.
However, that also means that at the rear, you're much taller than 10.9 meters. What is the height at the rear elevation?
Yeah. Well, the height from the rear is consistent with the, I don't have the exact number, but it's about a story lower because the grade goes about a story lower from each of those houses. So the same scenario to our neighbors at the east and west, the grade difference from the first floor down to the back of the property is about 1 full story.
Thank you.
Could I please see slide number... Slide number 3 of the presentation package.
Mr. Chair, I want to remind presenters that they cannot present material to the panel members because people who are hearing this online cannot see what you are seeing.
Thank you for bringing that up. Is it possible to put that document up on the screen? I don't.
It's not part of the presentation package, but it's part of the drawings.
Mr. Chair, if it is not submitted ahead of time, we cannot accept.
Is it in the drawings?
Yeah, it's in the drawing. It's just the rear elevation.
Can we pull up the rear elevation for everybody to see? And thank you for pointing that out. I would like everybody who's here to be able to see that drawing as well.
If I could mention a point, it's frequently seen that the grade goes from the front of the home to the rear in a downward slope. But in this case, the grade not only goes from the front of the house to the rear in a downward slope, but also from the street. In many cases I've seen where the grade goes from in a downward slope, at least the grade from the street to the front of that house is positive. I've seen that in planning where they create lots which wouldn't have our height problem from the front. Additionally, if everyone is done with the rear elevation, if I could see slide number 3 of our presentation package, we could see that there are a number of developments in the area which not only some of the developments have our same problem where there's a grade difference. For example, on the same street, we can see 600 Castlefield has been approved for a much higher height of 11.04 meters. But also in other parts where they don't have this problem, we can still see an increase in height. For example, at 327 Courtly Boulevard at 11 meters. And there is a number of homes which are completely flat-roofed buildings which still have asked for an extra height. For example, the second last example, 10.79 meters versus a requirement of 7.2 meters. That, if I can see slide number 6, please. Here, in slide number 6, we see a house with a height of just 9 meters. There are numerous examples of 9 and 10 meter flat roof heights, which I didn't even include in that chart, which you can see that once it's a flat roof building, the impact, the shape of that house is much more impactful than what we have proposed, where the front of the building actually comes down and then there's a slope of a roof. Additionally, there are many examples that are actually sloped roof buildings, but that hide the entire front of the building with their front wall. So you can have essentially a building which conforms to the building height of 10 meters, but because of the rule of how the side wall or front wall heights are calculated, the bylaw states that either the front or rear wall heights should be calculated or the side wall heights. And now with the new bylaw rule of where 30% of that sidewall heights are allowed to return from the front and the back, there are many numerous examples where a building which would conform to a 10-meter height limitation would be much more impactful than our building because the front of their buildings are taken to the top, taken to the 10-meter limit, while our building, the front wall is actually lowered. It's lower than 9 meters. So that extra height that we have requested, which is mostly because of the grade difference, the majority is hidden in the roof. It's less impactful than various houses that I've seen within a 50-meter or 500-meter radius of this application.
Okay.
Thank you.
Thank you.
Sorry, Mr. Chair, I forgot to mention, if I could see slide number 9, we've had numerous meetings, as we always do, with the neighbors, and we have gotten 3 letters of written support, the last of which came in late, so you don't have it as part of your application. But slide number 9, I think that's a different. Is that our? Okay. Right. The house is 529 Castlefield. Our adjacent neighbor at 524, and the rear neighbor at 523 St. Clement all have written letters of support, and the other 2 are verbal supports, including 532 Castlefield, who the neighbors told us to go and speak with that neighbor first. Apparently that neighbor is the leader or the main neighbor of that area who agreed to our application first.
Okay, thank you.
Thanks.
You have any additional questions? No additional questions at this time. Okay, thank you very much.
Thank you.
I believe we're prepared to move into committee for quick, brief discussion, followed by a motion. Any comments?
If we approve this application, can we impose urban forestry approval?
Certainly, and we would agree with that.
If you'd like, we can put the memo up, and it tells you what you can do.
Well, the memo is clearly asking for deferral.
If you read a little bit lower,
Yeah, it provides a couple of conditions. I think we should read those in for our motion, if we're going to.
can you see that on the screen now?
Yes, thank you.
Mr. Chair, the memo mentions that if there's an approval of the application, they would require, they would suggest and require those two conditions for urban forestry, which we totally agree with.
Yeah. Unfortunately, like as I stated before, it's not a remedy. It's if you know, a lot of times urban forestry will defer to a decision. If committee of adjustment approves an application that calls for injury or destruction of a tree, that is often. Is that better? Hello, testing.
That's better.
There were multiples of you, Mr. Chair.
It's to state, you know, to put forth what I said earlier. We have to consider these trees now. If we approve an application that calls for injury or removal, urban forestry, what it presents itself as it's essentially a conflict against what we're ruling on. So in the interest of and also, you know, in the interest of the 4 tests, we have to specifically acknowledge and address issues and impacts to urban forestry. There are specific parts of the OP that speak to that. So, Mike, I mean, frankly, I don't have concerns with the application except for the tree that was pointed out in the front yard, which is affected by the walkway. And if I'm correct, there is a variance that is before us today that specifically relates to that walkway.
No. I don't believe so, no.
Okay, so would you be able to just clarify that, please? Because maybe
Yeah.
I want to make sure I have a full understanding here.
Yeah. As I said, the part of the application affecting that tree are those steps, which aren't a variance themselves. There's nothing precluding those steps from being there, including the front yard setback encroachment, an encroachment of the porch itself. It's a very narrow, shallow porch. And in regards to urban forestry, Mr. Chair, every application, either an application would harm trees or it doesn't. If it doesn't harm the trees, then there's no conditions for urban forestry. Usually every application I've seen that would harm a tree would be in the middle of a driveway or within the building envelope that would require it to be injured or removed. There are conditions set out tied to your approval for urban forestry that requires us to go to forestry after the committee and deal with them. And in almost every case, Chair, where we've approached urban forestry before the committee, their response to us is, let's see what the committee says and then we'll take the application forward.
Okay, thanks. Unless there's any more questions, I think we should move into committee. Yes? Okay, thank you very much. We're going to move into committee now, so I'm going to ask that we limit discussion to our committee members at this time.
I do see that there's a front porch encroachment into the front yard setback, but I don't know if that's would have a significant impact on the tree.
Well, that is not a variance, though. It's allowed. variance?
Variance number 2, related to the front porch, which is accessed by the stairway that goes right through the tree protection
So
zone.
sorry for interrupting, but that's considered a second-story balcony. Sorry.
I cannot have.
It's a second-story balcony. It's not because of the front porch. Because it's a 3-story rule based on the new rule of the bylaw. They consider our porch to be part of a second story.
Mr. Chair, if you're going to take yourself out of committee and allow the applicant to speak, you should state so.
Yeah, we're in committee, so I'm going to, duly noted, let's just make sure that there's no misunderstanding here, and if there is any misunderstanding, I'm inclined to reach out to the agent for further clarification.
If you need for further clarification,
Yeah,
regarding
perhaps.
the question, perhaps you can take yourself out of committee just to make sure everybody is clear.
Okay, do we need further clarification on, with respect to variance number 2?
Yes.
Yes, okay, so we're coming out of committee. I'm allowing you to respond to variance number 2.
First of all, I apologize, Chair, for speaking in the middle of your committee, but it was a big misunderstanding. As I said at the beginning, the new rule of the bylaw, which is a very strange rule, honestly, has considered the basement of our home to be the first floor. The first floor is considered to be the second floor, and the second floor is considered to be a third floor, which doesn't exist. There is no third story. As a result, that specific rule has caused all of these variances, including a number 2, which says that a platform with a floor higher than the first floor of the building above established grade may not encroach into a required yard setback. We all know that a porch can encroach into a required front yard setback once it is a porch. This porch is not even only our first floor, it is lower than our first floor. This variance has considered that porch to be above the first floor as a second floor. That same rule has caused the rear yard deck to be considered a second floor balcony, which it is not. It has considered that front porch canopy to be non-conforming, which it is conforming. So that porch only has a variance because it is considered to be protruding from the second story.
Okay.
Sorry, but it still impacts the tree. Like the variance for that porch is within the tree protection zone. So regardless of what the bylaw considers it to be, it's still within the variance allows for that porch to exist in that proposed setback, which does, so it still does apply.
Yeah. I would agree with that. I mean, we have to consider the application in its entirety. I mean, if the application was before us and there was it triggered the bylaw in a different way because we have a reallocation of what we consider ground floor, second floor, then that's a different application. But we have to consider the application before us. I see a variance there for a front porch. I see a front porch that's in the middle of or very close to a tree that forestry is flagged. And for that reason, I have concerns with that variance. I don't see how it just, I'm trying to get clarification, but
Mr. Chair, may I
I
make
think
it
I
clear?
grasp the matter. I think I grasp the matter.
May I make a clarification, please, Mr. Chair?
Yes.
Can Irving upload the forestry's condition, please? There's a site plan in which the tree protection zone has been marked in red.
Yes, I did see that. Can we pull that up?
All right, as you can see here, the porch is not a problem. It's just the stairs. So there's no variance in this list which is directly related to the tree. The steps is in the tree protection zone of that tree, not the porch itself. Besides, if you read variance number 2, which is about the porch, it reads at the second sentence, it reads a floor higher than the first floor, while the porch is really lower than the first floor. It says higher than the first floor because technically this house is considered to be a 3-story, which is not. And as my colleague explained, everything relates to the topography of the house, which is unusual.
Is there a variance for the steps?
No, there's no variance for the porch steps.
That's what I'm trying to, did you have a look at that? They, essentially, the variance is limited to the porch, which just falls outside of that red line. But the stairs are also required to address the height as well, entrance height, which is another variance. You didn't have that, you wouldn't need the stairs. It's I feel like I have enough information at this time. If you have any other questions, I know we've expended a lot of time on this.
I mean, I think it's fair to defer at this point. Where a lot of, like, all of the variances come together in terms of whether it would cause impact to that tree or not. So I would like to motion to move to defer as per forestry's recommendation.
I'm willing to second that. I'm sorry, Mr. Chair.
I can't have you guys interrupt.
But this motion is already failed.
Such
motion was already failed.
We're in committee now. Okay. So we have a motion that Mr. Auspitz put forward to defer. It was seconded by Mr. Schwartz. Do we have? Is there a third? Do we vote on that? All in favor? So we've got 2. Opposed?
Yeah, I oppose that. I think the porch variance is not really affecting the tree, and I'm ready to make a motion.
Okay.
So before that, we have a motion on the floor. So
you have a motion.
Yeah, we have to finish with the Thank you. We have to finish with the motion on the floor.
Yeah.
So the motion did not carry.
Well, did it not carry?
Sorry, can I have that vote again, please?
Yes.
The last I had was that Mr. Schwartz seconded it.
Correct.
You're asking if there's anyone, is it all in favor? Or if you don't see a hand, you're asking for opposed?
Okay. I didn't see any other hands on approval of the deferral, so those opposed? And we have 3 opposed. So the motion fails. And do we have another motion?
Yeah, I'd like to make a motion. I'd like to make a motion to approve this application with the condition of urban forestry and also community planning memo. I believe the variances are not affecting that tree, and I think the applicant can move forward with the application.
Okay. Do we have a seconder? Second by Ms. Casson.
May I make what I consider to be a friendly amendment to that?
At this time, you may.
Okay.
Sure.
What I would like is that the wording say, subject to the condition of urban forestry, that the submission of a complete application for a permit to injure or remove a privately owned tree as per the City of Toronto Municipal Code Chapter 813 Trees, Article 3, Private Tree Protection. So that's the first part of my friendly amendment, right? This is to be precise in our motion, because the motion says subject to, I believe, urban forestry, and I want to articulate what urban forestry has articulated and put that in our motion for the benefit of their advice in their report. So the first amendment that I would like to say is subject to submission of a complete application for a permit to injure or remove a privately owned tree as per City of Toronto Municipal Code Chapter 813 Trees, Article 3, Private Tree Protection. So that's the first part of my friendly amendment. And the second part of my friendly amendment is subject to where there is no existing street tree, the owner shall provide payment in lieu of planting of one street tree on the city road allowance abutting each of the sites involved in the application, the current cash in lieu payment is 583.3. The reason I'm asking for that is that's the wording that Urban Forestry provided in their urban forestry report. I believe it's appropriate for us to articulate that in our motion so there's no misunderstanding.
Mr. Marjuri, is there any change to your that motion?
I am fine with that. I think Mrs. Schwartz can actually put forward a motion with those conditions. I'm fine.
Okay, very well. So I don't mean to belay this. Can I have should he state the motion again?
While we're left, Mr. Schwartz made a friendly amendment. It still is the first motion, so it's still on the floor. There's a friendly amendment. There was a seconder. Now you're looking for all in favor or any opposed?
Okay, all in favor with amendments as proposed by Mr. Schwartz. Okay, those opposed? Okay, the motion carries.
Thank you, Mr. Chair. Thank you, committee members and committee staff.
Okay, item number 1466, HILLHURST Boulevard. The purpose of the application is to permit an extension to the rear portion of the dwelling. Variances sought are for building length and building depth. I have on our file materials from the applicant, including drawings, diagrams, and an arborist report, as well as a staff report from community planning, as well as letter of objections from 181 and 201 Courtley Boulevard. Do we have the agent with us?
Good afternoon, Mr. Chair. Can you hear me? Can you hear me?
I can hear you loud and clear.
Thank you, sir.
Okay. We do have another speaker, so I am going to ask for a brief presentation on this.
Thank you, Mr. Chair. Just for the record, it's David Bronskill, 333 Bay Street, Suite 3400 in Toronto, acting as agent for the applicant, sir. I am going to suggest to the panel that this is one of the most technical variance requests that we have in front of you as I've ever presented. There is a previous approval that the committee should be aware of. If I could ask staff to pull up the 2-page presentation that we had provided, and just page 1, because it just highlights where variances were previously approved and what is different this time around. And then, Mr. Chair, I'm going to explain why something is different this time around just for the panel. So you'll see there the variances that we're seeking have all previously been approved, with the exception of building length and building depth. Those are greater than previously approved, from 19.43 to 23.01. But all of the other areas where there are variances granted, variances sought, such as setbacks, those have previously been granted by the Committee of Adjustment, but they're picked up again on the notice. The reason, and if staff could go to the second page of the presentation, the reason that the additional length and depth are being sought is as a result of, as the committee well knows, how length and depth are measured. Length and depth are measured to walls, and that includes where there is then underground excavation. In this case, subsequent to the previous approval, the high water table came into play. This has required a complicated and frankly expensive type of foundation. Committee may know it, a raft slab that's been used to ensure structural stability as well as waterproofing. That's required extra mechanical space that you don't find in traditional residential homes, and that's been put under the rear terrace. So in the previous approval, the rear terrace was not excavated. Now the rear terrace would have to be excavated. That means that the excavation under that terrace now counts that portion of the structure as length and depth. But in terms of what was otherwise previously before the committee, everything above grade is unchanged and is the same as previously before the Committee of Adjustment. And that's why the planning staff memo you have before you has a condition that I would both support and encourage the committee to impose, that ensures that the additional length and depth is not deployed above grade, but is only deployed below grade as a result of the excavation below that rear terrace. So that's why there's the additional length and depth being sought. There's nothing else above grade. It's to deal with the high water table. Mr. Chair, it results in no changes otherwise to the built form previously approved by the committee.
Okay, thank you very much. You have any questions? No questions? Okay, I believe we have another speaker to this item. From 203 Courtleigh Boulevard.
Yes, thank you. Appreciate this opportunity to express my objection to the proposed further variances for this subject property.
Okay, if you
My
could just
name is
state your...
Alan Hutton.
Thank you, yep. And your address?
203 Courtleigh Boulevard, immediately to the northeast of the subject property. We have lived here since 1981. We are not opposed to reasonable development in our neighborhood. We do oppose further variances for the lot at 66 HILLHURST Boulevard. The house already, as built to date, overwhelms the immediate neighborhood in every dimension. The 8 previously approved variances are collectively 219% over the existing bylaw. These 2 additional variances must be referred back to the original bylaw, not as increments to the approved variances. Additionally, the variances are being requested above this significant underpinning, which was dug a long time ago and completed, suggesting that this was always the plan and that these are 2 additional variances that literally are the straws that break a camel's back. The multi-dimensional size of the redevelopment reflected in the sum of the now 9th and 10th variances is ill-suited to our neighborhood and adversely impacts our property. We respectfully request that this application for the 2 further variances be denied. Thank you very much.
Thank you. Okay, any questions? No questions? Okay, if there's no other speakers, we will move into committee. You do have a... Thank you, Mr. Auspitz. Do we have the can we get the applicant back? And I apologize for that. Thank you for pointing that out.
Thank you, Mr. Chair. No apology necessary. I won't repeat myself. It's not 2 additional variances. I do acknowledge that they are increases to variances previously sought, but I would hope that the speaker in opposition might take some comfort, although they clearly don't like the house under construction that's on the site. There are no changes to that built form previously approved. There'll be nothing different visually for the owner, which I understand it, I think, is diagonally to the northeast. So there's no changes visually for that owner. And frankly, this excavation for the waterproofing and the roof slab, because of the high water table, is actually something that helps deal with water in general on the site and in the area, and I actually would submit to the committee as a benefit overall. Again, I thank staff for putting that condition up on the screen. It's vital that that condition be included so that the length and depth are only deployed below grade and that the built form, as I noted to you, above grade remains as previously approved.
Great, thank you very much. Okay. Prepared to move into committee now? Any comment? We'll give a...
I have a comment. I know we'd previously taken the position that below-grade structures were still considered structures due to permeability. However, I mean, I think those were a lot more significant, where almost the entire lot was covered.
Correct.
I don't think the same rationale applies in this instance. I don't have real concerns with the application. I think it's generally appropriate.
Okay. We have a seconder.
Do we have a motion?
It's not a motion.
A motion? I
We're-
thought you were making a motion. This is your
getting-
comments.
We're getting tired.
Sorry.
I would agree with my colleague and say that I think that this proposal would have no impact on anyone in the surrounding area, and therefore we could consider it as minor.
Okay.
I'd like to make a motion.
Okay.
I'll motion to approve subject to conditions of planning.
Okay. Do I have a seconder? Second by Ms. Casson. All in favor?
Well, I think, do we debate the motion a bit? I'm just, so I'm not necessarily.
We're in the middle of a motion, so if I
thought you had to debate a motion once it's.
Well,
first.
let's see where this goes, because we're already in the middle of a motion. We have to finish with it.
So my understanding of the
add your comments.
procedure is that you make the motion, somebody seconds it, then we debate it, then we vote on it. Is that not correct?
No, I think we will
We vote on it?
discuss prior to a motion being made. But I do apologize. I am trying to be
That's
mindful of
fine.
the
I don't need to say
of the
anything.
clock.
Just go ahead.
We have a seconder here.
So we have a seconder by Ms. Casson. All those in favor? Okay, those opposed?
I have something I want to say before I vote. Otherwise, I'm just.
I believe if you're opposed, we have no reason. Do we need I'm assuming you're opposed to the motion.
I'm not opposed to it. I just have a concern about it.
Okay.
That I wanted to share with the committee.
Okay.
And that concern is that this is not an opposition, but I think, I don't know if we've adequately considered the issue, which really was that this has already gone through a number of approvals, including T-Lab. Now, effectively, it's coming back to us again, which in my view is potentially an abuse. Is that not?
Mr. Chair, we're in the middle. I would need either you come out of committee and you allow Mr. Schwartz to speak.
Yeah.
Otherwise, I need a vote.
Yeah, we do. We can.
Well, that's my concern. Otherwise, I'll either abstain or vote opposed, but I'm not prepared to vote in favor unless I know the answer to my question.
Can we? Yeah. Let's. I mean, for procedural, conduct.
Mr. Chair,
finish with
at this point, Mr. Schwartz has heard evidence. There's 5 members. If we do not have 3 that concur, we have an issue.
I believe we. We have a seconder. We were in the middle of a.
That's all I'm saying.
Okay.
Because 5 have heard evidence, we need at least 3 votes that concur.
Okay. So let's go back to this motion. So Mr. Auspitz put forward a motion. The motion was seconded by Ms. Casson. All those in favor? Okay, we've got 3. Those opposed? We have 2 opposed. For the record, Mr. Schwartz and Mr. Allison are opposed. The motion passes.
Could we take a 5-minute break? I think it probably is.
Okay. We are 2 items from finishing the morning agenda. Let's make this very brief. 5 minutes. We're back here at 3:23, but no later, please.
Okay.
I didn't disagree with you. Good afternoon. It's 3:30. I do have to apologize. We are a little bit behind today, actually a lot behind today, and will do my very best to move the items through as fast, as quickly as I can. But I also want to make sure that each item is given the right amount of time, and that applicants and those who have showed up today are given the opportunity to speak and present their case before us. So we're moving on right now to item 15, 35 Fleming Drive. The purpose of the application is to construct a rear deck. And we've got variances for rear deck south side yard setback, rear deck projection, as well as variances related to the shoreline hazard limit and/or stable top of bank setbacks. Materials that I have are materials from the applicant, including drawings and an arborist report, as well as a letter from the Toronto and Regional Conservation Authority, as well as letters of support from 33 and 37 Fleming Drive, as well as email correspondence from Community Planning and Urban Forestry. Do we have the homeowner online, the applicant and homeowner with us?
Yes, thank you. My name is Jim Donegan, and I am the owner and applicant for the subject property.
Welcome. Can you just state your address as well, Mr. Donegan?
Yeah, it's 35 Fleming Drive.
Okay. To my other members, would you guys like to hear a brief presentation on this?
Is there any opposition? Is there any?
I don't believe so. Staff, do we have anyone else to speak?
Through you, Mr. Chair, there is nobody else here to speak in opposition to this application.
Okay. I don't see, and there's nobody here in opposition. I don't see any, nothing in my file that speaks to that.
Well, Mr. Chair, I mean, in order to expedite this, given that there's no opposition, what would be, I don't feel we need to hear from the applicant.
Sure. If I can just add something to that, I mean, to the applicant, we have received all of the material and we have reviewed it. If we don't need to hear a formal presentation, I will go back to the applicant and ask if there's anything they'd like to speak to the application at this time.
No, I don't think there's anything further. We're just trying to, I guess, move this along quickly. So I'll just, I'm available for questions in case there are any from the committee. Thank you.
Okay, very good. Yeah, that said, do we have any specific questions? No. Okay. We are prepared to move into committee for discussion at this time.
Could I move? I would like to put forward a motion to approve. I don't see any conditions. I know there's been correspondence by the TRCA.
Okay.
I'm willing to second that.
Do we have any recommended conditions of staff?
I don't see any.
No. Just confirming and nothing that came in late? Yes.
No.
Okay, very good. So we have a seconder to that motion that was just brought forward? We did.
Yeah, I second.
Thank you, Mr. Schwartz, second that. All in favor? The application is approved.
Okay, thank you very much.
Okay, item number 16, 83, is it Lytton or Lytton Boulevard? Lytton, thank you. 83 Lytton Boulevard. Just give me a moment. The application is a proposal to construct a new dwelling with variances requested for east and west side yard setbacks, as well as FSI. On hand, I have material from the applicant, including drawings and an arborist report. As well, I have a waiver of support from 83 and 87 Lytton Boulevard. Those are the immediate east and west neighbors, as well as 105 Lytton Boulevard. Okay, do we have the agent on the line?
Good afternoon, Mr. Chair. Mahir Manius of Monarch Design, number 1 Teakwood Grove, Toronto.
Okay, thank you very much. Just give us one moment.
Sure.
We need to hear would we like to hear a presentation on this, or do we have any, we'd like to move perhaps to questions of the applicant?
Yeah, I actually have a question if we are not in need of the presentation.
Well, I'm just going to bounce back to the agent. If there's anything you'd like to present, you've heard that we don't require a formal presentation on this, but if there's anything you'd like to state or add, I don't want to deprive you of that opportunity.
I'll make it sweet and short, Mr. Chair. So as you mentioned, the proposal is for a new dwelling to replace the existing one and the existing two-car detached garage in the backyard. The first variance being FSI, we're proposing 0.77 versus 0.35. I've argued this before at Committee of Adjustment hearings. The 0.35 is not meant to be adhered to. It's more of a control mechanism that all applications in neighborhoods like Lytton Park, Lawrence Park, and what have you get vetted additional scrutiny as to what's being developed. I've submitted as part of my presentation material, pages 3 to 5, I think, previous decisions in the neighborhood where they average in range from 0.68 to 0.82. So we're somewhere in the middle between those. Additionally, the proposed third floor is completely contained within the allowable roof line. We're not requesting any height variances or wall height. We just have a couple of small dormers on the west side and the back. So if you back off the third floor, which is completely hidden in the roof line, we're at 0.64 FSI. The two side yard setback variances are only for the front portion of the house, so we were proposing 1.22. The back portion of the side walls past those small areas where we're proposing the variances actually exceed the required setback by the bylaw. And as you can see also from the chart, this is one of the most common variances being side yard, as from when the 569 bylaw was passed, it changed the standard from 0.9 to 1.5 meters. So up to the bylaw 438, up to a few years ago, the building standard was 0.9, and even then there were some applications with variances. And as you mentioned, Mr. Chair, we do have support of both immediate east and west neighbor. And if there's any questions, I'm happy to answer them.
Thank you very much. We have any questions?
I have a question. The letter of support from the immediate east neighbor, which I think is 79, says that their support is conditional on the east elevation drawing showing a privacy screening. I don't see that on the actual plans that were included in the package. They were dated November 9th. Could you just clarify that?
Correct. So we do have a covered porch at the back of the house with a fireplace in it. So as part of our package, the neighbors, we did suggest, when I spoke with the neighbor at number 79, and because they also have a covered porch that basically faces this proposed porch, it's to the benefit of both my client and the neighbor to have a screen flanking the fireplace. So we did provide him with an east elevation that shows a permanent screen flanking those the fireplace. So as I say, it's to the benefit of both owner and neighbor.
But it's not included in the package that we're viewing today. Is that correct?
No, we did not submit that, Madam Chair.
Is there a specific height with respect to the privacy screen that's being proposed or agreed upon between the neighbors?
Actually, we didn't even put a height on it, but I would suggest 6 feet high.
Okay. 1.2? 1.8.
1.8.
Okay. Any other questions? Nope. Okay. Prepared to move into committee. Thank you very much. Just a small minor note. I particularly with this application, I found it very helpful in the elevation drawings that the applicant included the adjacent homes. It really helped to provide context and also helped to ensure that the scale and massing is consistent with the neighborhood and the street. So I just wanted to be specific about that in calling that out, because I think a lot of applicants may benefit from providing similar information to prove their case.
Thank you, Mr. Chair.
I don't really have any concerns on the overall proposal. I mean, if the privacy screen was agreed to, I think we should probably include it, and the applicant has acknowledged, I think we should probably have a condition. Yeah.
I would agree.
And my understanding is it's along the east elevation.
I think it's the covered porch element of the east elevation.
Okay.
Correct.
Okay.
Would you like to try to put a motion forward?
Just so it does say here, privacy screening as noted in the drawings. Is it noted in the drawings or not noted in the drawings? So it's not noted in the drawings.
I think it was. I think there was a comment made that it was not
Right.
included in the drawings. But I think we can deal with that with a condition of any potential approval.
I'll put forward a motion so I would like to put forward a motion to approve, subject to the inclusion of a privacy screen along the rear covered porch, being along the east side of the rear covered porch, being 1.8 meters tall.
I'll second that.
Okay, we have a second by Mr. Schwartz. All in favor? Okay, the application is approved. Okay.
Thank you, Mr. Chair.
Thank you. That concludes the morning session. Now, I have stated that we are running very, very behind, and I do apologize as chair. I will make every effort to move the afternoon session along as quickly as possible. It is 3:44 right now. Normally we would take an hour, but let's say is 45 minutes is sufficient with everybody. We can meet back here at 4:30. Oh, okay. Would there be any interest in you guys? Well, if from Mr. Schwartz, then yes? Okay, so pending no concerns from staff, I want to make sure everybody gets ample time to eat, because we've been in these chairs since 10 o'clock this morning. We will reconvene at 4:15. You were the one I